Check one, two. Hey, hey.
Hi, Anka. Can you hear me?
Yes, I can hear you.
Hi, Anka.
Hi.
This is Kuna.
Hi, Kuna. Can you hear me?
Okay. Yes, I can hear you very well. Just to
And you
check,
can,
your connection seems okay.
yeah, it's
And
probably going off and on, but we will see.
okay. Our team will try sharing the presentation. So just to ensure that you see it correctly.
Yeah.
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 Moment. Yes.
And
And you can say next slide and they will help controlling it for you.
yeah. And there will be questions and answers immediately, yeah?
Yes. Yes.
Yeah.
So
No,
Mr.
because
Francois
I'm
and
not,
Dr. Arwin will let the question and answer immediately after your presentation so that you can
yes.
go bed.
Yeah. Yeah,
All right.
exactly.
All right.
Great.
Okay. Oh, good. You can talk via here.
Hello, Anke.
Hello, Arvind.
How are you?
I'm fine. Tired of farmers' rights. It's really an awful discussion on farmers' rights already here. Incredible.
Yes, you are right.
Finally, they try to oblige to adopt something regarding the recommendation.
I'm afraid that there is going to be a big fight on that one, yes. We are only in the beginning, but we started, for us today or whatever, yesterday, we started the discussions on farmers' rights and whoa, that is
In
really,
plenary or it's
yeah, in plenary. And
okay.
it's going to be a contact group, I suppose, but no, it's really tough.
But what is the purpose of the secretariat? What is what they want?
Yeah, the idea is to come to guidelines, voluntary guidelines, and that is
Okay.
at stake. And
Yeah.
there is a lot of political pressure.
Ah,
on this.
yeah. We see you then. Okay. Very good. Right.
I can't see you guys, but that is okay.
We are still the same.
Ah, good.
Still as young as usual. Yeah.
Thank you, Kuna.
We'll start the session in a few minutes. So let us wait a few minutes. Please wait. Dr. Shivendra will go up and welcome participants and invite the chair.
Okay.
Yes.
Okay. I don't want to trouble the protocol.
Yeah, we can start in 2 minutes.
You may at
Please,
least talk to her.
talk on the microphone. I'll ask my team to show it. Yeah. Can she see?
Hi, Anke.
Hi there.
Now you can see us.
Okay. Welcome everyone. Welcome to the technical session on intellectual property and biodiversity. I'll request everyone to settle down. Yeah. So today we have a very important but longer session. It's about 4 hours, but divided into 2. So we'll have a coffee break in between. What we try to do is as our committee is working on intellectual property and biodiversity, which includes the access and benefit sharing. So we have designed the session into 2 parts. The first session, because of the logistics reason, we have kept a session on biodiversity and access and benefit sharing first, and then second session on intellectual property. So in the first session, we will speak about, as I said, on the ABS, and we have Anka from Plantum online. She definitely wanted to be here, but of clash of meetings, she's in Rome because the governing body meeting going on at the same time. So thanks, Anka, for staying up late for this meeting. Then Francois and I will update you on the farmers' rights, and then we have a Q&A session. And next session, we'll talk about the intellectual property. We'll start with Manabu-san about the UPOV update, and then about the PVP law in New Zealand. And then we move on to discussion to some of the prevention of illegal seed practices, and then on to CRISPR-Cas technologies, the licensing of that. So without further ado, I would like to invite our chair, Dr. Arvind Kapoor, to the dais, and the co-chair, Mr. Francois, to the dais as well. I won't pronounce his surname. So.
Yeah. Good afternoon. I hope you have nice lunch, and we have designed our program in such a way that you won't get the sleep, because mostly people get siesta after lunch, so we will not let you sleep. So we'll see that our presentations are quite absorbing and interesting to you. You see this session about the intellectual property and biodiversity. These discussions are going on for now very long time, and presently also I think the GB10 is going on in Rome. GB9 has happened in Delhi, and the access and benefit sharing. This is a very the subject which is, I think, very close to our hearts as a seed industry. And we know that in access, we have, under treaty, we talk about Annex 164 crops. And for the last 2 GB meetings and this current GB meeting, we are discussing about expansion of the Annex 1. And there are a lot of countries who want to expand it and put it into the multilateral system. But there are a few hitches somewhere that some of the material is not being put it into the multilateral system. So a lot of discussion is happening in that area. And both APSA and ISF, we are very actively participating to bring the consensus with the participating countries that what benefit it will accrue to the researchers and the industry. Benefit sharing, we know that at present we are going through the NAGOA protocol as per the CBD, but seed industry is looking into differently that instead of that system, we want to put the subscription system, which Anke will talk about it. In this session also the farmers' right, which is, though the industry doesn't want to have any conflict between the breeders' rights and the farmers' rights, We understand very well that farmers are contributing towards the conservation of gene pool, but to avoid any conflict, so we are putting our efforts to have the inclusive things with both with the breeders and the farmers. So we don't want to have the conflict between the two. So with these words, I first introduce to you Anke. Anke, as you know, the Deputy Director in Plantum and member of APSA for a very long time. And now she decided that she wants to take off from the as a member of APSA and also ISA, but she wants to take another option and another hobby. And she said, I will have enough in these discussions. And she did very well. And I can tell you, we will certainly feel sad about it that we are hearing Anke in APSA for the last time. But we hope that we will catch up with Anke anytime in future to get her guidance, provided she will give. So entire decision is Anke's. So now I invite Anke here to explain you about the access and benefit sharing of the genetic resources at ITP-GRFA and CBD. Anke, please.
Thank you, Arvind. And it's nice to be with you. I can't see you guys, so it's not the style I am normally enjoying, but indeed with the clashing meeting of the governing body, I could not be in Christchurch. I have to say that my internet is a bit unstable, so I hope the presentation will work out. But indeed, I had this long name of the presentation, Introduction and Update of Discussion on Access and Benefit Sharing of Genetic Resources at ITP-GRFA and CBD. Next slide. And I thought it would be better to see with you guys, like, okay, where are we with the CBD and where are we with the international treaty? Next slide. So what do I want to go through with you today is first a short update on, okay, let's recall what is the Convention on Biological Diversity and what does it entail with access and benefit sharing, and the same for the international treaty. Then I want to go into the latest developments. This was where I was already a little bit afraid for that I am kicked out now and then from the internet, but let's try to move on. Next slide. The Convention on Biological Diversity was really agreed upon in 1992 and got into force in 1993, really dealing with the conservation, the sustainable use, and the access and benefit sharing on the use of genetic resources. And especially the latter, that is always what have been important for us because we use genetic resources and what impact does it have.
I'm sorry, Anke, this is Kuna. If you still can hear us. Yeah, she got cut off again. So I'm going to request Anke to turn off her video so the connection will be better. So let us wait a bit when she comes back. Sorry for the inconvenience, everyone. So I think this is the challenge when we have the online speakers. But so far, we are still lucky that all the online speakers can make it, and hopefully Anke will make it today as well, because her presentation is really interesting. So she got cut off. Let us wait a bit when she comes back, because it's really early now in Rome. I think around 2-3 a.m. in the morning. So she'll be with us to present, and after that she will go to the government body meeting. So that's really tough for her as well.
Yeah, so sorry.
Hi, Anke, welcome back.
Yeah,
Can you
sorry.
hear me?
Yes.
May we request you to turn off your video? Probably the connection will be better.
Let's try it like that.
Yes.
Okay. Yeah, no, the internet is weak anyway. But okay, we talked about the Nagoya Protocol, and you would say, okay, Nagoya Protocol, where is it important for us? And it is important for the plant breeding sector, because the Nagoya Protocol led to national legislation in different countries. And I can tell you, more and more laws are formed in more and more countries. And there you need bilateral negotiations to access genetic resources, and you need prior informed consent and mutually agreed terms. It's complex, it is time consuming, and often not even resulting really in agreements. Your costs of breeding are increasing, and in some cases it leads even to the fact that people say, okay, if I work in such and such a country, I am not mixing my materials with other countries because it's very complex to mix. And so it means that you need a program for India, you might another program for, let's say, China, and another one for that one, which is not very convenient. It gives the companies more liability risks, and so a lot of people avoid the use of genetic resources. And in the end, it results in limited benefit sharing. Next slide. Then we had also already in a longer time ago, we had the CG gene banks with a lot of materials safeguarded in those gene banks to protect against being lost. In 1983, they made an international undertaking to share, to safeguard the gene bank materials and to allow people to use it in a common heritage approach. But once the CBD got into force, this common heritage approach was not in line anymore. And so the International Treaty on Plant Genetic Resources for Food and Agriculture was negotiated. And to really make the exchange of genetic resources work, they developed a standard material transfer agreement, the SMTA, in 2006. And the next slide. For plant breeding, the SMTA is somehow useful. However, several countries are not really giving out such an SMTA, even though they promised to do that. And the SMTA can only be used in principle for 64 crops. So if you are using another crop like tomato, like soy, you are not in this system. The SMTA is free for research and breeding, and only when it's not free for research and breeding, there is an obligatory payment system. If you use more genetic resources, it can deal with it, but it is an eternal contract, and there are some strict uses usage clauses. You can only use it for plant genetic resources, or you can use it for activities on agriculture, food and agriculture. Also here, the cost of breeding in the end increases with all these contracts. You have more liability risks, and also here, people avoid use of genetic resources, and there is limited benefit sharing, at least financial benefit sharing. Next one. Next slide, please. Yeah. Then the conventions, I put them now here in one sheet in the time frame, but I told you just now that so both for the Nagoya Protocol and for the use of the Standard Material Transfer Agreement, the benefit sharing was not a lot, or you could say not as people expected. So then further discussions came on how to go on, and then digital sequence information came into the picture, and we don't know yet when we are going to solve the problem on DSI, but the DSI also has some impact on the SMTA and also on the benefit sharing arrangements on the international treaty. And going next slide. So why do we talk about digital sequence information? And I can tell you, and I was asked before by guys from your region, what is digital sequence information? Nobody knows. Some people say it's just genetic sequence data. Some people say it is going on all information up to traditional knowledge and whatsoever. But we are not really able to come to a conclusion, and so people say let's not talk too much on the meaning of it, but just let's talk about benefit sharing. And indeed, they wanted to talk on DSI because these expected benefits, and especially for developing countries, they felt it's not enough and that they were not shared. And they feel that digital sequence information may be used to circumvent the use of genetic resources themselves, and so circumvent benefit sharing. Next one. And as indicated, the expected benefit sharing was not reached. And I think there are several reasons for it. And let's first face the expectations are far apart. And some of you who have heard me before, if you negotiate about a bottle of water between 1 and 5 euro, you are going to make an agreement. But if you are going to negotiate on a bottle of water between 1 euro and 10,000 euro, you are not going to come to a conclusion because the opinions are too different. Some people wanted to have benefit sharing on the past, while others say, no, you can only make benefit sharing on something what is looking forward. If you make a contract now, you can make agreements on that. But if you don't have agreements, then you are not going to have benefit sharing. And of course, it also takes time to develop products. The choice of genetic resources you use may depend on these benefit sharing arrangements. So you might decide to use only materials where there are not complicated benefit sharing arrangements. In the context of the Standard Material Transfer Agreement, we said already some monetary, and there is a lot of non-monetary benefit sharing with the breeders' exemption. And then, of course, what is fair and equitable? In the treaties, they are always talking about fair and equitable benefit sharing, but what is the value of a genetic resource? What is the contribution? What is the investment required? And so it's very hard to really see if and how expected benefits can be reached. Next slide. So, plant breeding and the use of DSI. Are we using as plant breeders DSI? And if so, from where? readers may do sequencing and then they generate DSI themselves. It can be used in the breeding process in combination with the genetic resource and other information. It can be used in screening of other genetic resources when looking for characteristics like molecular markers. And DSI alone is not, in general, not very meaningful for us. Only in combination with other information and the genetic resources, it will help us in the breeding program. And in some cases, some breeders also may access public databases and even the INSD databases to compare data and sequences to really get more knowledge on the genetic sequence from our materials. Next one. Can I get the next slide?
Now we know that she got hijacked again. Okay, everyone, request for your patience. She will be back. All right, thank you so much.
So I'm back on, I think.
Welcome back.
Sorry about that. 7 slides to go, guys. I hope I can make it.
We'll be with you. We'll be with you, Anke.
I already said that plant breeding and the use of DSI is happening, and that if we are working with DSI, it's impossible to know what the value of the contribution of the DSI is. It's impossible to track the use of information, and readers should be free to use their research results. So sequence information, whatever it is, should probably not be regulated. In Montreal, in last December, they decided we are going to regulate digital sequence information. They came to the so-called Kunming-Montreal Global Biodiversity Framework, and they had 4 important decisions, and one is on digital sequence information. Next slide. And there they had agreed, and you see here the official language, but they had agreed we are going to agree that there should be a mechanism to share benefits from the use of digital sequence information on genetic resources. And they said it should not become like in the Nagoya Protocol bilateral. We should work on a multilateral mechanism.
We apologize for this inconvenience, everyone. Let us wait in the meantime, the chair and co-chair. In the meantime, if you have any question to Anka, please reserve it because we'll have the Q&A right after her presentation so that she can log out and prepare for the next meeting in early morning.
So now what we can do, we will present the slides and you can read it. And when she will come back, and then you can ask. Is there? No. So I think we will present the slides, remaining slides. And when she will be back, we will have questions.
Okay.
Hi, Anka, can you hear us?
So go to the next slide.
Can we move to the next slide, please?
Yep.
Okay. Read it. That's slow.
Can you hear me again?
Yeah.
Okay, maybe. Yeah, I have to get into my flow. I need to. Can you go back one? I have a number I'm going to call now, and then I hope to get back in a more stable way to you.
Go back one. Yeah. Okay. Yeah. Okay. Go ahead.
Yeah, I'm trying to call a number that maybe we have a better connection.
You want to go quickly through the slides first?
Yeah, I go quickly. So this decision, we are going to work on a multilateral system. Can you go to the next slide? And in that, they are now going to work on a multilateral mechanism on benefit sharing of the use of DSI. They are making an open-ended working group to really come to a solution. They met last week in Geneva, and they were brainstorming, and on 5 topics you can see here on the slide, but it had nothing to do yet really with the mechanism on what it should look like. It was all kind of elements turning around the hot pot on how are we going to develop a system, how are we going to generate money, because that is what it's really about. And they had a little bit of conversion on the 5 topics, but a lot of non-conversion and a lot of need for further discussions. And they are planning in the coming half year, they are planning 9 meetings online, and you can imagine how our online meeting is going, how that's going to be. And they hope to have some further progress in August 2024, whereas a second open-ended working group will meet. And in autumn of next year, they want to have a system going. Now, I can tell you that system going is not going to happen. It's going to be really tough, and to really come to a mechanism is still very far away. However, if that mechanism is not going to be formalized, people are going to be very upset, and then there will also not happen a lot of work on the conservation of genetic resources and the conservation of biodiversity. But this is what it is. So that is in the CBD context. Next slide. Oh yeah, this is what the seed sector is contributing now. We need, and if we are going to benefit sharing mechanism on digital sequence information, we need the following criteria. We should have open access to DSI. We should be able to access it in all times, and we see then how we deal with the benefit sharing. It should become a mechanism that is legally certain and predictable, and it should be especially very clear on scope and be prospective and not retroactive. It should have cut-off criteria and clear definitions. We should not have a stacking of obligations of payment or whatever, and possibility to include genetic resources in one system, so that you don't have to pay and for genetic resources and for digital sequence information. And it should also recognize the international treaty, because there we also have benefit sharing mechanisms, and that should not be another payment obligation. And of course, if you do this, it should support the conservation and sustainable use, the money that is going to come in, so that it really helps to have the biodiversity conserved in the end. Next one. So the digital sequence information has also an impact on the SMTA, and especially the enhancement of the amendment of the SMTA. And we are currently in Rome discussing how we should amend the SMTA. And it is estimated that in this meeting in Rome, we are going to decide on a process, because indeed, yes, those discussions are long and time consuming, and you first go into process and then maybe into content. So it's probably going to decide here that we are going to have 4 ad hoc open-ended working group meetings in the coming 2 years to have a new SMTA, an amended SMTA in the 11th governing body in 2 years' time. If that is going to be successful, I don't know. We are dealing with the following topics on the next slide. And people indeed want more benefit sharing. Up till now, during the last 13 years or 10 years, we received about 400,000 euros, and people are very upset about that, but they don't value the breeders' exemption. They don't value the fact that they have new varieties that are good for farmers and society. But they want an obligatory payment for all kind of, in all kind of ways you pay. If you access in a single access, or that you go through a subscription system, so like a membership fee, but they want obligatory payment. There is discussion of the expansion of the list of crops, and indeed, the most hot topic, I would say, is how to deal with digital sequence information. Next slide. So where are we as seed sector in this topic? We want a package deal. It can't be that we are going to pay more and that the list of Annex 1 crops is not extended. We want the expansion of the list to all PGRFA. We, as a compromise, we said we can live with obligatory payment as long as it's reasonable and workable. And we want one system for genetic resources and DSI. We don't want to go into all kind of double payment, and the payment obligation should not be eternal. So having the next slide. So, and I think it's clear from my presentation, which was maybe a bit difficult today, but it's clear that benefit sharing is really having a negative impact, and that we really need to discuss with our officials.
We no more hear you, Uncle. Huh? you know how to read it. Yes, you are back.
Yeah,
but
it's my last slide, guys.
Yes.
So
because I think it's important to have the possibility to have some questions for you. So
okay.
Go again. Thank you, Uncle.
So it's more favorable for bigger players. We can't help in all the tough climate crises, diseases and whatsoever if we don't have access to genetic resources, and if we are not developing a system that is economically viable for us, that will not create benefit sharing, and it will also probably have a negative impact on in-kind activities we do. Next slide. And this is where I wanted to end, and I said already, expectations. And I hear all the time, also here in Rome now, yeah, we expect more money. We expect more from the private sector. The private sector should do this. The developed countries should do that. It's about high expectations. And I found it interesting when I looked for pictures that expectations are really need to be tempered to really get to reality. And with that, I would like to thank you for your attention. And we get to the last slides with all those abbreviations, but the story is not going to end here. It will continue, and you will have a lot of work still ahead on dealing with those topics. Thank you very much.
Thank you, Anke. Thank you very much. We will now go quickly for the questions. Anke, you are there, no?
Yes.
Yeah,
Hello.
please.
Oops. Hello, Anke. Here's Kaula from ISF. Thanks a lot for the great presentation. I have a question. I wanted to know who is from the governments driving this all new discussion on DSI and at the CBD.
Thank you for your question. I think it's a good question, and that is a bit the unfortunate situation in this discussion, that it is really a geopolitical fight almost between the G77 countries, so the developing countries plus China normally, and the OECD countries. And yeah, all developing countries are following the leaders in that field, and they are following the NGOs, while the OECD countries, there is a more, they want at least a reasonable and a realistic system.
Yep. Any other? Yeah, please.
Hi, Anchor. This is Gao Mingzhu from WaySeed, and we provide cross-border registration services for seed companies. So we totally understand that you talk about the status quo that's happening in Plantum and all those hurdles we are facing, because it's just really hard to really share ideas and materials in the seed industry. So I would like to ask, like in the past a few years, let's say 3 years, what are the achievements that you would say that Platinum has made in terms of the resources sharing and those electronic, data sharing? Thanks.
It needs to be clear that Plantum is not exchanging genetic resources or whatsoever. We are trying to represent the seed sector on these difficult topics in the international negotiations. And I'm pretty sure that a lot of breeding companies are still working with genetic sequence data, either creating them themselves, working with markers and so on. But yeah, in the meantime, this discussion on digital sequence information is ongoing, and it might be that especially international databases might.
Any other question? Yeah, please.
Maybe you can take this question, sir. Yesterday we discussed on EDV. So in relation to that, is there any relation or the timeline that is figured out for this and EDV? Because there is some kind of overlap that's going to happen here.
Anke, you have understood?
She's not there.
Anke?
Cut off.
So what was your question?
Yesterday we discussed on EDV explanatory notes.
Yes.
And this is coming now. So is there any timeline set for this? From when this it's going to be implemented?
I don't think anybody can say that
No.
they have a timeline. And
No.
there are discussions, there are parties, they have to agree. So there are diverse views, we know that. Bring them to the same consensus level. You never know whether they come in one meeting or subsequent meetings, we don't know yet. There's nothing, a charter of timeline is fixed for these discussions. Anke, if you are there, thank you very much.
Yeah. Thank you,
Thanks a
guys.
lot.
And I'm sorry. Thanks again for listening to me. And good
Have a
luck
nice-
with the rest of the meeting.
Have a nice sleep and ready for the next meeting. Thank you.
Bye-bye.
Bye. Sorry for that interruptions, but this topic is really, very informative. and she tried to explain us the complexity. And we have to go through these pains. We know that as a seed industry, but we will continuously follow it up, pursue these kind of discussions, and see that it brings some comfort in future to all of us, and no conflict with any of our stakeholder or with the governments. So moving to the next our discussions, which is on the farmers' rights. You know that there's a lot of debate happening globally now on the farmers' rights, and this area is creating issues between the two stakeholders, between the breeders and the farmers. But I think without going into those kind of discussions, Francois will update you on the farmers' right debate. And we have two presentations here, one by Francois, another by Shivendra. So first, Francois, please go ahead.
Thank you very much, Harvey. Do you hear me? Yes. So, in a way, I have to say I'm so sorry to take your time to talk about farmers' rights, because normally it's not something which has to be taken into account when we are working on ITPG-RFA and genetic resources. What happened? The concept of farmers' rights, you may imagine it's a very old concept, but it's not true. It's very, very new. Actually, some organizations started to talk about farmers' rights at the end of the 80s, when we started also to work on the use of genetic resources, not only for food and agriculture, but for everything. And when the countries started to work to have a system to say, okay, if somebody in the industry is using a genetic resource and is making a lot of money with this genetic resource, and sometimes it's not fair that the country where this industry went to have access to the genetic resources has no profit at all about the money which is done with it. It's why there was the discussion in what we call the CBD, and which was adopted in '92. And what is the main purpose of a CBD is to say, okay, before the genetic resources were a common public good, and now we decide that genetic resources are under the sovereignty of the states where these genetic resources are. And in a way, it may be fair, but immediately you have two discussions. The first one, which is linked to farmers' rights, is some people said, yes, okay. But my problem is what was done before the CBD with my genetic resources, my parents, my grandparents, and on. During millennia, we work on these genetic resources, and you are doing some money now. So what is my part? And regarding the plants, and especially the breeding, and I'm sure a lot of you know all the pictures made by ISF about that. It's not so easy. You can say that the potato you are eating today is the potato from Peru. This potato from Peru was going in a lot of countries, was changed a lot. And so if we say, okay, we have to pay everybody who is who did something on the potatoes plant, it's finished. So how it was solved, I will go back to that. It was solved to say, okay, we can't go back to the past, but we may recognize how farmers were so fantastic. Second problem, you know that to do breeding, you need genetic resources, you need access. So the reader said, if I need to negotiate with each country to have access to their genetic resources to make my breeding program, it's impossible. Especially if each country say, okay, you want my wheat, you have to pay 1 million. And if I need wheat genetic resources from 4 countries, I may pay 4 millions without any insurance that I will obtain a new variety and I will do money. So we engage a discussion at the level of the countries to say, okay, we need to have something special for food and agriculture. And this something special is the international treaty. And because of specificities of breeding, the international treaty said, okay, we will create some multilateral system with a free access to all the genetic resources of the member countries of the treaty. It means that all the countries which adopted the treaty said, okay, you want access to my varieties in the public domain, my genetic resources, my land resources, no problem, it will be free and for everybody, and you may use it. So this negotiation was done in a way very quickly because it started after the CBD and it was finally, it was adopted in 2001 and into force in 2004. So in this treaty, we talked 2 times about farmers. The first, as I said, is, okay, we say we don't, it's impossible to give some money back, but we may recognize the fact that farmers, for their past, present, future combination, they contribute to conserve, to improve, and making available crop genetic resources for food and agriculture. As usual, it was a negotiation between countries which want more, and especially developing countries which said, oh, it's not only the past, it's also the future. And developed countries which said, okay, in the past it was true, but today it's more our breeders which are in charge of the conservation and improving of genetic resources. But at the end, we have this phrase. And the second thing is to have an article, Article 9, on farmers' rights. This article has 3 parts. 1, 2, everybody agree. The idea was to say, okay, genetic resources are very important for farmers. And so it would be logical that farmers will be part of all the policies regarding the genetic resources, regarding, of course, what we are doing with genetic resources. So it means regarding the seeds, for example, to have farmers' organization in the registration committees and so on and so on. But you have also an Article 9.3, because some countries which were against intellectual property rights on seeds, against breeders' rights, want to use the treaty and especially the farmers' rights against breeders' rights. And so they said, we want in this Article 9 something to say that the right of farmer to sell seeds, it's so important, we need to write something on it, the right to sell. And of course, the developed countries said, okay, we may accept that if you had that it's depending of the national legislation of each country. So we have an Article 9.3, which say the farmers have the right to save, use, and sell seeds, depending on the national legislation. And of course, as soon as we start the implementation of a treaty, some countries insist on the right to sell, and some countries about the national legislation. So, what was the situation in the beginning of the treaty? The main purpose of the treaty, as I said, is to give access to a lot of genetic resources, free access and easy access. And this part was organized with the SMTA that was presented by Anke before. And this part works. You have 100,000 of SMTA which are signed and mainly used by the public institute in all the underdeveloped countries and developed countries, and developing countries, excuse me. And so this part is working. But as I said, some countries, some organization of farmers like La Via Campesina, some NGOs, were frustrated by the Article 9.3 about this fact that it was depending on national legislation and it's up to the countries to implement farmers' rights and not of the treaty. The treaty, in the text of the treaty, has no responsibility on that. But they didn't accept. And so they try to each governing body, every 2 years, they try to grab something. You know, they started to say, oh, maybe we may help countries to know how to implement farmers' rights. And after they said, oh, maybe we may have some options. After they said, oh, maybe we may have guidelines. It's what we are talking at the governing body in Rome these days. And the other countries are saying, no, but I remind you that it's not the role of the treaty to work on farmers' rights. It's the responsibility of the countries and their national legislation. What is the problem in that? The problem is, as very usual in international negotiation, the seed sector is weak regarding the countries where the seed sector is important. What I mean? I mean something very easy to understand. The turnover of all the seed companies in all the world is third of the turnover of Nestlé or Unilever. So at the end of the day, the politicians are more interested by what Nestlé is saying than the seed industry. And so we have this problem. And at the opposite, faced to the developed countries where you have some seed sectors, you have countries, you have NGOs, you have organization of farmers who said, oh, you are not fair with the poor farmer and so on, the poor stakeholders. And sometimes you may take a country like Norway, for example. Norway has no seed sector, except they have one public company. And the turnover of the seed sector in Norway is around, I think, around 10 million. So they don't care to say, oh, breeders' rights, we don't need. And they say, farmers' rights is important. And because politically, it's more interesting for Norway to have this position at the international level than to defend the breeding. If you take the region, if you take in consideration the fact that China is not member of the treaty. So China has a strong seed sector, but they are not member. New Zealand is not member of the treaty. So you have Australia, Japan, and Korea, which are mainly the three countries which are talking about breeders when there are some discussion in the treaty about farmers' rights. All the other countries which are members of the treaty, countries from ASEAN, you have always the feeling they don't know that they have some seed companies, because they always not talking about seeds. And to give you very easy example, not this governing body, but the last one, 1 year ago. At the opening ceremony, there was a lot of things regarding farmers, the importance of farmers in the conservation, genetic resources. And Canada proposed to add just a phrase in a 2-page resolution to say that breeders also may have some importance regarding biodiversity and seeds. And it was refused by the majority of the countries, who said, we have nothing to do with breeders. Yes. So the reality is the fact that all these countries forgot first the Universal Declaration of Human Rights, because in this declaration you have an Article 27 to say that every human has the right of protection of what he is doing, he is creating. And you have more than that. You have, because the Human Declaration of the Universal Declaration of Human Rights is not binding in many countries. But the majority of the countries of the planet, 150, they sign also what we call a covenant on economic, social, and cultural rights, which is binding and with exactly the same than the Article 27. But everybody forget that. And at the end of the day, in many countries these days, if you are a singer or you write a song or you write an article, you have no problem to have a copyright. If you are a singer, you write a song in 5 minutes, you have rights for 50 years after your death. And if somebody in the same country is creating a new variety with 10 years of breeding, he has no right at all. So this is a problem. So what is today the situation and what we want in the seed sector? We want first to say, and it was said by Michael Keller at the beginning of the governing body Monday, the fact that what we just ask is the right of farmer to have choice. If they prefer to have all varieties, public domain, they may. If they prefer to use their seeds, it's not a problem for us. But we want that it would be possible also for farmers to have access to new breeding, new varieties, and good quality seeds. Secondly, we have not to oppose farmers' rights to breeders' rights, especially because in many countries, farmers may become breeders. And so breeders' rights is also part of their rights. And we recognize that a lot of progress may be done for the Article 9.1 and 9.2, so the participation of farmers in the regulation. And finally, and it's very important also, because in many countries, it's a case of India, for example, they have some, in the name of farmers' rights, they put in place some instruments which are illegal regarding the treaty. For example, the treaty said that you guarantee free access to genetic resources. If in a country you say, okay, you want to have access to what we may call farmers' varieties, which were created 100 years ago, you have to pay something. It's against the treaty. So it's very important when we work on farmers' rights, how to implement it, to continue to remember what is the purpose of the treaty, what is important in that. What is important is the free access to genetic resources. Thank you very much. I was too long.
Thank you, François. So we'll go for QA after the second presentation, because that is on the same farmers' rights progress. Shivendra?
Thank you, Dr. Arvind. I'd like to make an update on what happened during the recent symposium on farmer rights in Delhi, in India. So ideally, Francois should have audited, but he wasn't there and I was there, so I had the responsibility to do that. As Francois in his slide rightly mentioned, why are we talking about farmers' rights, first of all? And why seed sector has to be bothered about farmers' rights? Nobody denies that farmers don't have rights, but because as he said, farmers are central to agriculture, so there are rights for him. He did mention about Article 9, so I'm not going to do. The only thing is that what we would like to debate and discuss is that there are perceived conflicts, what is proposed in farmers' rights, as well as what are the seed-related policies and law, especially on the PVP part. And now this debate is showing up in more and more discussions, not only just the TT and the CBD, but in general seminars. Even we are talking about farmers' rights and DSI, although I'm still unable to understand the link between these two, but there have been a lot of debates happening in this area as well. So what Anka did mention about the ITP GRFA TT, and she's there in the GB10. I would like to highlight only the TT's recent work on farmers' rights, but I acknowledge that there are many other instruments, especially within the UN, that are discussing farmers' rights and making significant progress. So many years ago, or rather a few years ago, the international treaty decided to create a ad hoc technical expert group on farmers' rights. That's called ATEC on farmers' rights, and many acronyms are here. So I apologize for that. But this farmers' right, this ATEC on farmers' right, which was appointed by the treaty with Norway as chair and India as co-chair, wound up its recommendations last year or slightly late 2021 and made some recommendations. And basically, they made recommendations, whatever you can imagine, whatever is possible. So it's very difficult to narrow down on the possible 1 or 2 key critical recommendations that this ATEC group did. So what they did was they classified their recommendations in 11 categories and provided within those categories, they provided different options. So there are 11 categories of recommendation and there are 32 options within those 11 categories. So if you have the time to read, you're most welcome to. I'm not sharing all the options here. You can go ahead and go to the TT's website and follow this link, follow this diagram, and you will find the options, the detailed paper there. Having said, I just cut pasted the first 2 options. So you can see they're pretty broad. And these are the options and categories. They really cover virtually everything in the world. So it's very difficult to narrow down what exactly are the recommendations. So basically, they try to be as inclusive as possible. And I believe that that's their mandate as well. So, they want to incentivize the farmers for conservation of the resources. They want to highlight the role and expertise of farmers and the communities by, mentioning by mentioning their names and details and giving prizes and awards, and then also providing within a legislation about their rights. So one of the other recommendation that came out during the governing body 9 meeting in September 2022 in Delhi was to have a global symposium on farmers' rights. And India kindly agreed to host that symposium as well. So that symposium was held in September 12 to 14 in Delhi. And this is a snapshot of that symposium. And I mean, you can imagine the value and the political significance of the farmers' rights in India that the President of India inaugurated this session. So she was there to make the inauguration. It's a symbolic, but you can understand the task ahead for the seed sector if you want to initiate a debate on farmers' rights in our region. So what is our view? And I'll come back to the recommendations or not so recommendation of the symposium. So what is the seed sector view here? And this is the position that all the seed organizations, NSAs, the seed associations, and gather together within the umbrella of ISF and develop these positions. So obviously, access to good quality seed, nobody is denying that. Every farmer need access, whatever market, whatever kind of system they have access to quality seed. They should have a choice to what they seed, what they buy. And the choice of farmers, and that's our key point, that farmers have a choice. The choice of farmers should be the focus of the national implementation if the countries are talking about farmers' rights. So coming back to the symposium, so it was clearly mentioned, although it was part under the umbrella of the governing body, the ITPGRFA, but the Secretary General clearly mentioned in its opening remarks, this is not a negotiating discussion. This is a forum for just experiences, sharing of views and thoughts, and making recommendations. So there was, after 2 days of discussion of experience of sharing of experiences, finding evidence of farmers' rights, rewarding farmers' rights. In the end, when it was not in the agenda of the discussion, the delegation from India, the host country, they decided to propose a Delhi declaration. So that's why I put in a question mark, was it a declaration or not? Eventually, it was not, but it was proposed. So they proposed, and again, as you can see that, and I just put some highlights here in the declaration, that they want the countries to accelerate the options that was advocated by the RTEC on farmers' rights. They want the secretariat, the treaty secretariat in Rome to develop more mechanisms for capacity enhancement. They want countries to establish a mechanism for creation of farmers' rights, and then advocates those mechanisms across various UN instruments. And Francois mentioned about human rights, Anka mentioned about CBD, treaty. There are many UN instruments where farmers' rights are discussed. They also recommended strengthening of benefit sharing fund. They want a special package on climate change, which means that, creating a special package for those farmers who might be, harmed by the climate change, the crops might be destroyed by sudden floods or drought and all. So, and they also wanted the countries to acknowledge the traditional knowledge. And to make a legal provisions of farmers' rights. But as I said, this was introduced at the last minute, in the concluding session of the symposium. There were few countries who did have representation, as part of the official delegation. They said that they really need time to review this, and I'm sure this would be discussed during the ongoing meeting in Rome this week. So I think this is a good forum for us to have a preview what's coming on farmers' rights. You can see the discussion is getting more and more politicized here. But at times, there are no different views from the seed sector and from the public sector. Seed sector also says that right to make a decision, right to participate in decision making is the key central to farmers' rights. And seed sector absolutely supports that. So how do we say that farmers have right to make participate in the decision making process? Through inclusive decision making process, there should be a balanced legal regulatory policy framework which provides space for the farmers. It also provides a option and choice and choice for the farmers to access good seeds, promote breeding, promote adoption of new varieties, and the formal seed systems in the form of seed sector as well as the informal seed sector seed system can coexist. The seed sector doesn't believe there is an overlap or there is any kind of a conflict here. So as Francois also mentioned, and Anka did also mention in her opening remarks, the discussions are slow, but they are laborious, but they are very useful. It's absolutely important for the seed sector, seed industry to participate and provide their views in those meetings. So with that purpose, ISF has established a task force on small farmholder rights. Marianne is one of the co-chairs of that task force. So here there is a participation of all regional seed associations. Some association have views on farmers' right, but not all associations have yet views. So which means again the task for this task force is to develop a position from the seed sector on farmers' right, and that could feed into the treaty and to the UPOV level. And I think that's my last slide. Thank you so much. Thank you, Chandra. Any questions?
Yeah, thank you. Any questions to both the speakers?
Okay. Thank you.
Oh, there is one. Surendra, there is one.
To one of you guys, thank you for the great introduction on this topic. My question to you, what is the definition of smallholder farmer? Is there any definition somewhere, in any legislation? Thanks.
I think you know the answer. Yeah, so no, there is, of course, the definition is depending of each country. Even only in one region, in Europe, for example, a smallholder farmer in France is an average farmer in Poland. And of course, if you take Brazil and Burkina Faso, you will have something very different. So it's totally a political concept. It's but farmers' rights are not concentrated on smallholder farmers. It's a concept. As I said, it's a mix because, for example, you had some years ago, you had a resolution which was presented about the right of peasant and people who are living in a rural area. You have an article in this declaration of United Nations on seeds, which said exactly, which is the opposite of international treaty, the opposite of the TRIPS agreement, and this was adopted by a majority of the countries of the United Nations. And even, you know, even many countries in Europe were ashamed to say no, so they abstain, you know, because it's very difficult to say, oh, I'm against the right of peasant. And of course, you had in this declaration something about land. And we know it's true that in many countries till now, you have no ownership of land for farmers. So it's a mix. But as I said, the main problem is that you have some organizations which are against intellectual property rights for principle on plants. They are not against on books, it's only on plants. And they found an opportunity in the treaty to use it against, and especially against UPOP.
Yeah, I can just add to one thing, Kaula. You mentioned about definition of smallholders. In my previous role, I did a study on seed laws in 7-8 countries in our Asia region. I could not find a definition of farmer. They say small and marginalized farmer, but there is no particular definition based on the land holding size.
Thank you. Again, Francois, to you, my next question, historically, for me, just to get the good picture on this. So when the treaty was a discussion in 2001 and then was entered into force in 2004, did the reader really get this idea that Article 9 will be just a bloom of farmers' rights and it will be really a big thing after accepting this?
No, but not only the breeders, even for many countries, it was not a subject. They say, okay, we give that to some people. What is important is to find an agreement in the treaty regarding the access to genetic resources, regarding some benefit sharing agreement. But so at the beginning we don't care, and even to be honest, in APSA at the beginning when this committee, the standing committee was a standing committee on intellectual property rights at the beginning during many years, and we started to introduce something about genetic resources slowly, but for many companies in Asia, they don't see the problem. And for me, the problem is clear. You have really a risk to have a problem of access at the end of the day. And you know, just before the CBD, there was Merck. Merck is a big company regarding medicine and so on. Merck signed an agreement with Costa Rica saying that in this agreement, all the genetic resources for medicine of Costa Rica were the exclusivity of Merck. And Merck paid a lot of money to Costa Rica. And one of the problems we had for the treaty, you had some developing countries against the treaty. Ethiopia was against the treaty because Ethiopia had the feeling that they had a lot of genetic resources, and maybe in bilateral agreement, they may have a lot of money. Because in the benefit sharing fund, the problem, the money is not going back to the country of the resource which was used. It's a fund, and after with a fund, you have activities to support genetic resources in countries. But you may use a genetic resource from Senegal, and the money of the fund may go to Philippines. So all the countries which have the feeling they have a lot of genetic resources, a lot of potential money, they don't like the treaty. They prefer the Nagoya Protocol and the CBD. So some of them will not be so sad if the treaty collapses.
Thank you, François.
So quickly, the last question we have to move forward.
It's a question from my side to both of you. Under the farmer right, if the farmer is producing seed, is saving the seed for himself, okay, this safe seed, we call it, whether the international agencies or the international organization is taking it legal, because if the seed companies are producing the seed, we have to abide by all the rules and regulations. So how it is being taken under the farmer right, the farmer safe seed?
No, I think there is a, you say during seed production. Is your question is for seed production?
Because farmer has the right to produce the seed and he can save the seed. Yeah, so how that seed, safe seed is being taken, whether it is legal or...
No, there are two things. One is that the farmer is saving seed from his commercial crop grown, and which is the pure varieties or those varieties. And if they are saving seed from there, they have the right on the harvest. The whole discussion started with the harvested material and where the breeder's right starts, where the breeder's rights end, and where farmer has rights on his own production. So I think for the seed production, you have a bilateral contracts. I think there is hardly any confusion there because most of the contracts where farmer is producing seed is producing under the guidance of the company who's producing the seed. So there, if there is somebody is keeping seed or stealing seed, that is illegal because you have the contract. But if farmer is taking your seed, buying your seed and growing as a commercial crop, and then saving seed from there, and then either growing in his own fields or bartering it or selling it to the other people, there the discussion has started that how far, because that is where the treaty says sell the seed. But most of the law says unbranded. They can't be brand or name of the variety. So I think that is where the things are. Yeah.
No, the answer is clear. The treaty says nothing about that. The treaty says in the Article 9.3, it's the responsibility of each country to decide what is legal, what is illegal. And it's on that we insist. It's important because some organization wants to give the feeling that we are against, for example, when we are French, we are against the fact that in some countries it's possible to sell seeds of breeders when you are a farmer. It's not our problem. We don't like the national legislation of India, but it's up to India to decide what they want. And when we are in India, we respect the law of India. So we just ask that the treaty respect also the legislation we have in France or in Europe.
Now we move for coffee break.
Yes.
And please
Yes.
come in by
2:40.
2:40, because we have very interesting presentation on by the UPO on the membership, and also on the plant variety protection law in New Zealand. And then we have a discussion on the CRISPR. And most of the people want to know what is the, on the patent issues. Patent issues are there. So please do come. There is a very interesting presentation now after the coffee break.
More interesting than
Yeah. So please come with the coffee, or you can bring coffee inside so that we can start the things earlier. the coffee, and there are a few people still outside, so we'll request them to come inside. We are going to start now the next session on intellectual property rights. Before I invite Manabu Suzuki, there are a few announcements to make. The one announcement is that the person sitting next to me, Francois, is also now retiring from the co-chair after this session, and the new person will come. And I'm very thankful that Francois, so long he served this this section on standing committee, a very active participant. He was chair of the committee and as a co-chair also, and very active participation for all the issues which we had, and really started a discussion in APSA countries and parted knowledge and update them that what is happening globally in these issues. So thank you very much, Francois, and we all clap it for his active participation. After this session, he will retire from this position. Moving forward, we will have the first presentation, update of UPO membership and member services from Mr. Manabu Suzuki, who is Technical and Regional Officer Asia of the UPO. Thank you very much.
Hello. Yes. Thank you, Alvin. Good afternoon, everyone. And thank you. And maybe it's connected to the war, maybe. Thank you for providing the opportunity for me to share the updates of the UPO membership and also the members service that we have launched very recently. So let me start with the UPO mission, which is to promote an effective PV plant variety protection system with an aim of the development of new plant varieties for the society as a whole. And now we show that these pictures, and we have new by Secretary General, the Yolanda Hurta, who was the legal director, and she became the new Vice Secretary General from October, taking over the role of the Peter Barton, previous Vice Secretary General. And the status of the UPOF, and this is one of the information I'd like to share today, is here you can see that the green colored the country nations is a UPOF member, and the brown and the orange colors are in the process of the contact and become the UPOF member. And then you can see in the Asian Pacific region, there's some countries that are in contact with the UPOF and then are in process of the UPOF membership. For example, Kazakhstan, Afghanistan, Mongolia, Myanmar, and then recently allowed PDR and Timor-Leste and Thailand as also there, or just including they would like to reach the UPOF to clarify the UPOF convention. And I like to just share the very new data on the number of applications made in UPOF members. As you can see, we see the number of applications grown very recently. And then we have there in 2022, more than 27 applications made in UPOF members. And then this is very interesting that we have here in the region, Asia and Pacific, the UPOF received so many application. It's no. Here you can see the Asian Pacific region is a major part of the members that received the application. And you see their trends from 2002 to 2022. The Asian Pacific region became the #1 region to receive the application in the UPOF. It's now the Asia Pacific region and account for more than around 56% of the application in UPOF. And then come back to the mission of the UPOF. It's the very important part of the UPOF system. UPOF is to provide the effective plant PVP system to encourage the new plant varieties for farmers and society as a whole. And to become the UPOF member, as you know, that the UPOF is a specific requirements to become a UPOF member, to have the role which conforms to the UPOF convention. And then there are the UPOF council who will need to give the green light to the country to become a UPOF member. And now I'd like to share the UPOF strategic house to achieve the UPOF mission, which we have 3 pillars. The first pillar is very important. It's existing one to bring together stakeholder, the breeders, farmers, and all society to help shape the UPOF system to become a UPOF member. And for this, we have been shared the information. What are the benefits of the UPOF membership in all the UPOF member countries? They have so many of the example in terms of the economic impact, environment impact, and then farmers incomes increase. For example, in case of Vietnam, we have the very good example. After Vietnam become UPOF members, they have observed the land productivity, which corresponds to, for example, rice. 1.7% of the yield increase has observed, and corn as well. And also the GDP, they saw the $5 billion per year because after the joining UPOF membership in 2006. So this corresponds to 2.5% of the GDP of Vietnam, so which is enormous impact they observe after becoming UPOF members. And now it's a very new videos to illustrate the UPOF membership in Vietnam. Actually, I was the director of this video, and it's launched very recently. There is 4 storylines. For example, the first one is farmer breeders. Farmer become the breeders, and they benefits. They protect their varieties, and they get money. So they very use the farmers as breeders. As a breeders, they get some other benefits by protecting their new varieties. So very interesting story, very individual level. And also the other example is a cut flower industry, Dalat in Vietnam. It shows that the farmers get access to new plant variety of flowers. And then that's plant flowers and exported to the countries, Japan and US and other countries. And then the farmers get money. by using the new plant varieties. And also the transformation seed industry demonstrating the various breeders involved in the plant breeding after becoming UPOF member. And also the last one is national agriculture policy, which shows what the impacts in general in Vietnam demonstrated, interviewed by to the policy maker in Vietnam. So the key message in video is the UPOF membership is to provide more choice for farmers. In addition to the current, the existing varieties, new plant varieties, UPOF provides more choice for the farmers. And also we have the workshop laws and the trainer course in Geneva to provide information about the benefits and what is the UPOF convention. And also we have so many other opportunities given by APSA and also the APSA and the US regional workshop Mekong that in June to October this year as well. And other work have been done with a partner of the European Union and Japan. The second pillar is provide information guidance of UPOF system. And I have the discussion with Monday in the EDV matters, explain notes are being the revised. And also other matter is harvest materials, how to clearly clarify the scope of the part breeders right on harvest materials, and also the small farmer or smallholder farmers, which in relation to the private and non-commercial use of the new plant varieties. And last pillar is a new one. It's provide high quality service of UPOF for UPOF members and also the users, which is the breeders and especially the UPOF system. And now we have launched a UPOF EPBP service platform in Vietnam for the first time ever in September 28th in Hanoi. I just want to explain what is a UPOF EPBP, but Vietnam is the first UPOF member to use start using the UPOF EPBP, starting from Asia. UPOF EPBP is the comprehensive the IT service to help the UPOF members to manage the application and examination. Also, they facilitate the communication between the breeders and also between the UPOF members. The first one is that UPOF Prisma, which already under UPOF provided back in 2017, that the applicant will be able to file application through UPOF Prisma online application system to file an application efficiently. In addition to that, we have now the launch to provide the UPOF EPBP administration module, which help the UPOF members, especially for UPOF members, to manage and manage the examination and application examination efficiently, and which enable the applicants to get the contact with the PBP office more conveniently. And also the UPOF PBP office can manage their contacts, communicate with breeders, which can benefit for applicants. And the information, it could be pushed into the UPOF Pluto database, plant breeders PBP's the database, which is available for the users, applicants. And the third part of the UPOF PBP is the US report exchange modules that's be able, the members, UPOF members, to exchange DOS the reports. So UPOF system enable to facilitate the cooperation between the UPOF members, especially for the DS examination, which requires the field trial, which is not easy for all countries to do every DS trial, but the cooperation in DS examination is a very important part of the UPOF. And now we have the actual practical platform IT tool to facilitate the UPOF members to cooperate to DS examination, which means that the applicants will be expecting to, for example, the one country already conducted the DS examination, that's the DS report produced that country be shared with other countries more easier than before with this module. So this is under the UPOF EBBP, now launched from the Vietnam, and other countries are members, for example, the European Union, Netherlands, United Kingdom, and then Ghana in Africa, already mentioned that showed a very strong interest to use these modules to facilitate their PBB system, also the cooperation in DS examination. So this, I just wanted to summarize. This is the last slide. The benefits of UPOF EBBP, benefit for PBP office, the all UPOF members will be able to have this efficient PBP system, PBP administration system. And then important thing is the system itself is maintained by UPOF office. So only very minimum costs should be borne by the PBP office of the UPOF members. And also it provides a secure environment in terms of the in line with international standards. And a very important thing is for not only for the PBP office authority, that plant breeders and applicants will be able to file an application and also obtain a PBP right more efficiently, and expect to be the cost to be reduced. And then by increasing the number of applications in the UPOF, the farmer also, the society as a whole, to get benefits by get the more access to the new plant varieties in the UPOF members. So thank you so much, the presentation. If you have any question, I would like to take.
Thank you, Mr. Suzuki. Any question? Yes, please.
Thank you. Hello.
Yep.
Thank you, Manabu, for that interesting question. I'd like to ask what kind, well, there are still many non-UPOF member countries. I'm talking about especially the Philippines. And in the map, we are orange. we have started, we are a 1978, we have the 1978 convention, but not 91. So may I ask what kind of support can UPOV give to countries like who want to pursue, because the seed industry is pushing our government to become members, but we also need the support of other organizations like UPOV to convince, our government to become a member of UPOV.
Okay. Thank you for the question. Very important question. And I cannot show the map again, but I think I will say that the UPOV can provide the first one is to provide the collect information. What is the impact, positive impact in the UPOV members? This is the most important part. There is so many details, discussion, what's the provision it is. It is also important, but what is the impact of the PPP, UPOV PPP system is the most important part. And then as I explained some of the example in Vietnam, maybe those material are shared with discussion stakeholders in countries. And the second one is we're still now struggling to how to reach out to the stakeholders, but I think we will need to consider not only to address the misunderstanding, but also how to make the stakeholders get together. And then what is the most important things for farmers, not the, the criticism something, but the farmer is the key part of the key part of the decision to encourage the policy makers. Yes. And then third one is the traditional. It's very important, but they provide information, the analysis of the law. If you have already PPP law and UPOV 91, then we have the advice. If they're requested, then we can provide information. Those are one is for we can offer if we request from the nation, we can. And also, as I mentioned in the DUS examination, DUS is really complicated for some of the country. They cannot conduct DS trial all the species. But I think the UPOV member, we have so many green colors UPOV members. They have one of the, for example, the Switzerland. They don't have the facility for conduct DS trial, but they ask to provide DS trial reports. And then those are the things is very important part of the membership UPOV. But yeah, sorry, so I have said so much, but thank you for my question. Yeah.
So we learned that 56% of the applications came from Asia Pacific region.
Yes.
Would be interested if the breakup between the developing Asia and developed Asia. That would be interesting too.
Yes, in Asia Pacific, yes. Very simple question. The answer is the number of applications in China is growing really, really fast for past 10 years. Well, we have created the animated graphic. I don't have it right now, but the number of applications in China has grown very fast. So that leads the Asian Pacific region as the #1 region. Yeah.
No, you know that in China, They're not charging any fee. It's free.
Yes, right. That's the one.
So by doing free, in 1 year, they got more than 11,000 applications. So you can see so that is why it's looking 56% and from 29 to 56%.
Thank you for this.
They did that to encourage breeding. No, it's, you know, at the opposite, you have the example of API, which is the African Organization of Intellectual Property for French-speaking countries. And you know, API, the cost is very expensive. And Africa is still representing 2% of the number of applications because very, very few companies use OAPI system because of the cost. And so it's clear that it's a good policy from China to say, I don't ask you any money. And so I would like to add two things. First of all, it's to answer Marianne. And please, Mr. Suzuki, don't hear about what I will say. You have not to take in consideration the colors of UPOV, except for the brown one, the green one. They are officially UPOV members. The two other colors, UPOV is intergovernmental official organization. So they have no choice. If a country apply, even for example, India is in brown. But India is in brown for years and years and years. And India has no intention at all to become member of UPOV. They said to UPOV, I will become member when you change the UPOV convention. So, but because they officially apply, they are obliged to put on the map. Secondly, it's important to understand because UPOV can't very much support seed sector which want to go because again it's a international organization. They need to respect all the diplomatic procedure and so on. So if I look on Ghana, for example, Ghana was supported by my organization for all the workshops they organize, and so we were in the shadow normally, but NGOs knew they protest, but we were not officially organizer. But we give money to the Ministry of Justice because in Ghana is the Ministry of Justice and to the Ministry of Agriculture to organize with farmers some seminar to explain. You know, in Ghana, the NGOs said, oh, UPOV is for NGO, is for GMO. So they need a lot of work just to explain that there is no link between UPOV and GMO. And it's possible to forbid GMO and to have UPOV rights. So I encourage you first more to ask help to Plantum, to SEMAE, you know, and to some countries which may be interested to push your seed sector.
So, okay. Okay.
No.
Yeah, we actually asked support from the Dutch government, and they're funding now knowledge transfer. So it's a capacity building program, and for the seed sector in the Philippines, and one of the objectives is in fact prepare the pathway for UPOV membership, and we have sent the officials, the policymakers of the Philippines to the Netherlands, to Naktaimbo, and see the seed sector. And also, I think the government also has applied for an awareness raising workshop under the East Asia PVP, and that will happen next year. So we are trying, at least the seed industry.
Thank you. Varnami, I have one question.
Yep.
Yes. How you are dealing with the Article 9 of the treaty in UPO?
Article 9.3. Yes. Okay. So I think of this discussion already. Yeah, the France are already addressed, and then this is the convention and the treaty, and then for the party, the primary speaking, it's the member of the party to the treaties, and also the members of UPOs. And we have the countries that's they're becoming all the bounded to the treaties as well as UPOF. And then we have, I forgot the number of the country, but there are so many other countries the parties to both the treaties and UPOF. And then I'm not sure that I can say at all on the detail, each detail, but the Article 9.3 of the treaty says to the subject to the national regulation, national legislation of the country. So of the plant breeder protection system, and it's subjected. So I think it's depends on the country to how to implement the Article 9.3 of the treaty.
So if it is so, if the 9.3 is a jurisdiction of the country, then like country India has the same clause in their PVP laws, the same Article 9. So so if it is the jurisdiction of the country, then why UPOV is objecting to that clause?
So I think firstly the India is not a member of the UPOV so far. So, and then, India is a party to the treaty, the ATPJ here. So, and if the India become the UPOF member, I think it depends on the country's legislation. But in case the India is becoming UPOF member, it means that the India has the plant breeders' right law in conformity with the UPOF convention. Okay. So okay. This is, so I know that's the discussion, discussion with India, was they try to become the party to the 1978 Act. Yes. And but it's still hold good for them. Yeah. So that's I don't want to touch on that. No.
Thank you very much. Thanks a lot. Thank you, Mr. Suzuki, for nice presentation and giving quite information about UPO. So now we move to the next presentation, the new amendment of plant variety protection law in New Zealand by Dr. Jackie Broadhead. She is PVR Examiner, Plant Variety Rights Office, Intellectual Property Office of New Zealand, Ministry of Business, Innovation and Employment, Christchurch.
Yep, microphone's working, great. Just like to thank the organisers for inviting me to speak today. As mentioned, well, I'm a plant variety rights examiner, so work in the DUS trials, and the Plant Variety Rights Office has a whole team of 5 people, and we're all here today, sitting over there, including one of our members who's based on the North Island, and she's also here today, so it's great for us all to be together. So we come under the Intellectual Property Office of New Zealand, under the umbrella of the Ministry of Business, Innovation and Employment. So, there we go. So I just want to give a bit of background to plant variety rights, as we call it in New Zealand, also known as plant breeders' rights in other territories, or more generally plant variety protection. So plant variety rights enables a breeder to protect their variety and provides opportunities for commercialization and hopefully some return on their investment. To be able to be protected, the variety needs to meet certain conditions, and these are that it has to be new, in that it's not been sold or offered for sale. It has to be distinct from every other variety of common knowledge, and it has to be uniform within itself and stable over generations. It also has to have an appropriate denomination, and all these conditions are outlined in UPOV 91, has been discussed earlier, and that's the convention we follow. A few facts about New Zealand plant variety rights. So in 1973, royal assent was first given to the Plant Variety Rights Act 1973. And in fact, I think it was yesterday or the day before was the 50th birthday. We did celebrate with cake, but that was last week, so that was very nice. So in 1976, the first grant was awarded. And then in 1981, New Zealand actually joined UPOV. I've just missed a vital date out here, which is relevant to the presentation, in that 1987, the Act, which I will be discussing as the old law, the Act 1987, came into force. And then in 1994, we had protection extended to fungi as well as plant species. In 2002, we had PVR fees became enforced. In 2003, the PVR joined the Intellectual Property Office, where we are now. And then in 2022, which is what we'll be discussing later, we started revision of the law as we will have today. So generally on a yearly basis, we have approximately 100 applications, and around 350 varieties are under test each year. At the present, we have around 1,300 valid grants. Of these, which are probably more relevant to the conference over this week, is the agricultural and vegetable varieties. And last year we had 44 applications filed. So it may seem not many when China have 11,000, but when you consider that New Zealand has just over 5 million people and China has just over 1.4 billion, when you do the per capita, we're actually not doing too bad. Just to defend our little country. So the main part of the presentation is about the new law. So the new law came into force earlier this year on the 24th of January 2023. And the law includes the Plant Variety Rights Act 2022 and the Plant Variety Rights Regulations 2022. I'll refer to these as Act 2022 and Regs 2022 through the presentation. So the major reasons for the new law were basically to do with New Zealand joining the Comprehensive and Progressive Agreement for the Trans-Pacific partnership, quite a mouthful. And to be members of that, we had to take effect to UPOV 1991. We also are obliged, or the Crown is obliged to have responsibilities to Maori under the Treaty of Waitangi. And the Treaty of Waitangi is an agreement that was made between the British Crown and Maori chiefs in 1840. And also to promote innovation and economic growth in New Zealand. So just a little bit more detail on those. So the UPOV Convention was originally adopted in 1961. It has then been revised since in 1972, 1978, and 1991. So New Zealand's updated law is actually based on UPOV 1991. So it follows all those conventions of the latest UPOV convention. So the Crown's obligation to the Maori has led to the formation of a Maori Plants Variety Rights Committee. And this will be established by the 18th of November 2024. And this is to protect the Kaitiaki relationships with Teonga species and Matarangi Maori in the plant variety system. So basically any species of importance to Maori or Maori knowledge will be covered under this. So that includes indigenous plant species, also non-indigenous plant species of significance, which includes species that came over to New Zealand in the Waka by the early Maori. It needs to be noted here, though, that varieties belonging to the species which have been bred outside New Zealand will not actually be covered by this. So, for instance, if a Kumara is bred in Australia and then they want to protect it in New Zealand, it would not have to go in front of the MPVC committee at the present time. Innovation and economic growth. So as we're all well aware, breeding technologies are advancing rapidly. They certainly have since the day I first did my PhD. And really, UPOV 91 brings us a bit more in line with those new technologies. We also hope it will increase the scope of protection, so it encourages breeders to develop new varieties because they should be better protected. And then also to create that balance between the interest of plant breeders, growers, and others, so that hopefully society benefits as a whole, and probably climate in the end as well. So a bit more on the increased scope of protection. So if a person wants to use a protected variety, then he needs to seek the authorization of the breeder, and he must get authorization for any reproduction or propagation, offering for sale or selling or marketing. And these were covered in the original Act 1987, which is the old Act. But the new conditions are such as conditioning for propagation, might be seed cleaning, for example, for exporting, if you want to export out of the protected territory, or for importing, if you want to import into the protected territory, and also stocking for any of the above. So those are the conditions that are included in the new law. And these are all listed in UPOV 1991, as well as the new Act. So what is propagating material? So in the Act 2022, propagating material is defined as any part or product from which another plant with the same essential characteristics can be propagated. So obviously with the advances in biotechnology, most plant material could arguably be considered potential propagating material. So situations may come down to the intent and purpose of the use of any seed or parts of plants. So it may be a situation where you have treated seed and you're selling it at a time when it should be sown. That could be considered propagating material. Or the other extreme is you have untreated seed that is being sold to a farmer that's going to feed his livestock, then it's arguably non-propagating material. But so yeah, there'll be a lot of intent and purpose discussions. Monday essentially derived varieties were covered quite comprehensively in some good discussions in the session then. So just a reminder, this is also included in the new law and new act. So essentially derived varieties are predominantly derived from a protected variety. They're clearly distinguishable, retain the expression, the essential characteristics of the initial variety. And the intention of this really is for the original owner of the initial variety to have potential on sharing the commercialization of the essentially derived variety. So also included in the new act is the rights over harvested material. So the PVR holder of a protected variety may assert their rights over harvested material, including entire or parts of plants where there has been unauthorized use of propagating material. So this only applies if the PVR holder has not had reasonable opportunity to exercise their rights in relation to the propagating material. So arguably, generally a breeder should be asserting their rights at the propagation stage, but if for any reason they have not had that opportunity, then there is potential to assert their rights later down the commercialization chain. As it stands at present, there is no definition for harvested material either in UPOV 1991 or the Act 22, although there are explanatory notes on this. So the main changes to the New Zealand system, so we only accept online applications now. We did originally accept paper applications. There's slight changes to provisional protection, restoration is included. The Plant Variety Rights Office has a more definitive role. We now include algae as well as plants and fungi. The term of grant has been amended for certain variety species. Nullification is now included, and the hearings and objections provisions and the new freeze regime have also been included. So I'll just discuss these in a bit more detail. So yeah, so as I say, it's only online applications now. We require photographs with vegetable applications. Denominations now have to be provided within 12 months of the application date. Originally, it was right up to the term of grant. And restoration is now allowed. So originally, in the old acts, you could not restore any lapsed or cancelled PVR applications. So lapsed applications would occur during the time of examination. Cancelled PVR would occur during after grants, if for any reason. So provisional protection in the old law, whilst your variety was provisionally protected, i.e. still going through examination and before grant, if anybody had any opposition to the application, then they could actually progress proceedings on that. However, in the new law, you will not be able to commence proceedings until that variety has been granted rights. So the office has a slightly more definitive role in the sense that a PVR cannot be granted unless the variety has undergone an actual physical growing trial. This doesn't necessarily have to be in New Zealand, as discussed earlier. We quite often use test reports that have been completed in other countries. But some growing trial has to be carried out somewhere. And the commissioner now has more say in how that growing trial is run and the type of growing trial we require, because we have that will vary on the circumstances and species of the variety. The commissioner may request propagating material or information for granted varieties. So this becomes important when we're actually organising our DOS trials, because we need certain comparator varieties and certain reference varieties. And if we can't access those, then the trial isn't as robust. And basically, this is in the interest of all breeders of new varieties as well as those with existing varieties, because you don't want to have a variety being protected that's the same as your variety that's already protected. And so failure to provide information on material could potentially now lead to cancellation, so that we have a little bit more leverage. Term of grants. So originally woody plants were just for 23 years, and potatoes were originally just for 20 years. These have now been given 25 years, both categories. And all other plants, fungi and algae are 20 years. And again, this is from the dates of grants. So nullification wasn't in the old Act. This is now included in the new Act. So if any information at the time of application was knowingly provided and that was incorrect, then this can lead to termination of the grants. And if this is the case, then that actual variety is taken to have never been granted at all. We have a amended hearings procedure. So you can now use the Intellectual Property Office to run the hearing system. And hopefully this will give a more transparent and clearer process for breeders. And as it's entirely separate from the Plant Variety Rights Office, it should give more objectivity and neutrality as well. With the new law, we introduced a new fees regime. So it has a slightly clearer structure. There's also been an increase in fees, and this will again go under review in 2025. The fee types are the application fee, so basically initial application, the test trial fees, and then a final examination fee before grants. The test trial fees vary because that'll depend on the species and the type of trial that's run. Other fees are more administrative fees, such as the cancellation, nullification, request for hearings, and further information is available within the Acts and also on the IPON's website. So we now have two laws because the new law has no retrospective elements to it. So rights granted under the old law in the 1987 Act will remain as they are and follow those rules. Applications prior to the 24th of January 2024 will be granted under the old law, the 1987 law. So again, it will follow those rules and you'll have none of the new law benefits. However, and obviously applications post 24th of January 2023, when the new law came into force, then they will be granted under that and will have all the benefits of the new provisions. And this potentially could mean that we will still have varieties under grants from the 1987 Act, like well into the 2040s, depending on the species and time of examinations. So just to summarize briefly, so we substantially unchanged for what us as examiners do in the DUS trials. We do have slightly more say in how the trials are run. The new fees structure has come in. Obviously, the new law has greater scope of protection, brings us up to date with the UPOV 1991 convention, the inclusion of the concept of the EDV, the amended hearings procedure, and such inclusions of restoration and nullification in there. So on that note, I'd just like to say thank you very much for your attention and welcome any questions.
Thank you, Dr. Broad. I hope it is very clear to understand the New Zealand law and the amendments. I hope there's no question.
Just one. Just one, Mr. President. No, I just want to know if you may give an example of a fees. How much for a wheat variety?
For a wheat variety, I can't remember the top of my head because it's all new. $3,200, is that dollars? Yeah, $3,200. Yeah.
3,000.
So, hey?
3,000.
3,000, yeah. Peanuts.
Thank you. Yeah, please.
Fit into the scheme. Is it a species or an isolate, or is it some property of the fungus, or does it have to have an interaction with the plant? Thank you.
So basically it has to meet what UPOV consider is a variety. I can't remember the exact Manimbu. I can't remember exactly how that's categorized anymore. But yeah, so it has to meet what UPOV considered to be a variety. So it still has to be its own form. And if it passes that, then it can have protection. So the main reason why we have fungi included is because of the endophytes, which are present in grasses. But we also just recently have had an application for a Penicillium roqueforti, so for a cheese mold. So it doesn't have to be related to any symbiosis with plants. But as long as it meets the description of what a plant variety is, then it can go through the system. So that's where we start the initial investigation or examination.
Thank you. Thank you, Dr.
Okay, thank you.
Yeah, thanks a lot. Moving on further, now we have presentation on illegal seeds in Asia by Ms. Thalima Soriano, Director, Crop Life Seed Regulatory Affairs.
Good afternoon, everyone. Thank you, organizer, for inviting Crop Life in this event. But in behalf of our executive director, I'll be presenting this topic, illegal seeds in Asia. So basically, illegal seeds continue to be a problem in Asia, having adverse effects on field productivity, regulatory system, and farmers' income, and all of which significantly affect the overall capacity of sustainable food agriculture, food production. And moreover, illegal seed practices carry intellectual property implications, which may reduce farmers' access to products from reputable producers. This is the outline of this presentation. I'll be talking about simple thing about Crop Life Asia. and industry view on illegal seeds, current status of illegal seeds in Asia Pacific region, and how do we act to address these illegal seed practices. Yeah, before going to the main topic, I'll be introducing about CropLife Asia. And CropLife Asia is a regional nonprofit organization dedicated to promoting plant science that is based in Singapore. And it's part of CropLife International. And under CropLife Asia, we have 15 national associations across Asia Pacific, and we are working in global federation, having regional and national associations in 91 countries. And as you can see on the right side, on my right side, we have 6 global R&D company members who are active in the crop protection and plant biotechnology and seed space. And these are BASF, Bayer, Corteva, FMC, Sumitomo, Syngenta, and Simplot as associate members. This slide shows that CropLife Asia advocacy is to sustain sustainable farming using a wide range of solutions that incorporate nature and technology that would benefit farmer, government, consumers, and the environment. And CropLife Asia focus both on crop protection and biotech and seeds. This slide presents the 4 CropLife companies, and we have Bayer, Syngenta, Corteva, and BASF, who are very much involved in fighting to resolve the issues on illegal seeds. This slide basically food safety and proper food safety and sanitation practices are public health concerns that must be addressed in order to achieve food and nutrition security. Food safety will continue to be increasingly critical area of concern as the food supply becomes even more global. So it is clear, that the challenge of keeping food safe is highly interconnected and globalized world must be addressed in a way that is collaborative and coordinated. And this requires committed resources, improved communication, and directed efforts to achieve safety and sustainability in the convergence of animal, human, and environment health. So what now is the industry view on illegal seeds? Because industry is facing a lot of challenges to combat these illegal seeds. Actually, there are confirmed prevalence of these cases occurring everywhere, which then is a threat to food security. There is a limited capacity of regulatory bodies to effectively manage the sale, trade, and use of counterfeit and illegal seeds, or these illegal seeds are not being taken seriously as other products, considering its far more serious implications. So government and industry have to establish a working coordination in order to address the problem, or there must be a strong linkage among stakeholders to address these illegal seeds. So what is now is the industry and farmers' perspective on illegal seeds. Illegal seeds put the productivity, income, and families of farmers at risk, reducing their capacity for sustainable food production, undermine intellectual property rights, and the innovation cycle. Also, illegal seeds have adverse effect on longevity of the technology and regulatory system, which I will discuss later. And farmers often purchase illegal seeds under the assumption that, they are more cost efficient than purchasing genuine seeds, but there is no special guarantee, or they are in low quality, or they are low in varietal purity and low germination. So these spurious and illegal seeds infiltrate also in the government subsidy programs and e-commerce platforms, like very common in Philippines. And also illegal seed practices, it misled farmers and erode their confidence in formal and reliable marketplaces. You know that not only these practices provide farmers with less income, thereby damaging confidence in seed quality, but they also undermine IP practice protection, safeguarding innovations, which are essential to support farmer livelihoods and increase food supply for our growing populations. Increase of these illegal seeds occurred in CLA-focused countries, like, for example, China, India, Indonesia, Pakistan, Philippines, Thailand, and Vietnam, where we are doing our seeds advocacy. So several seed practices can qualify as being illegal. For example, illegal seed practices often occur during the vegetative propagation, reproduction also, and marketing of seeds which are covered by the plant variety protection or a patent. And this might start with the theft of patented plant material or parental line hybrids. So therefore, to curb the further incidence of these illegal seeds, it has become imperative that government should be able to address how their laws or regulations could be able to provide legal protection and redress. And if they remain to be effective deterrents against those who engage in illegal practices. So the industry has been in partner with other seed associations, like, for example, we partner in Philippines with Philippine Seed Industry Association and also with TASTA and government in advocating policy changes. So as to the current status of illegal seeds in the Asia-Pacific regions, several cases of fake seeds that have been investigated and prosecuted in China. It's not only rice seeds, but also cotton seeds. So recently in India, the police caught 2.65 tons of fake cotton seeds, and Indonesia, the police there have successfully identified suspects and secured convictions in court for those involved in seed counterfeiting. So it's resulted in 5-month prison sentence with a total of 500 kilograms of counterfeits confiscated, ready for distribution. So imagine they are already caught. In Indonesia, the counterfeiters are caught by the police. So illegal seeds comes in different forms. As you can see in this slide, the most common type of seed counterfeiting are repacking rejected seeds, stealing seed on farm, because some of the farmers are stealing seeds in the farm, adulteration, and dressing grain with artificial colors. So they are also reusing certified seed bags for fake seeds. While counterfeit seeds are fake, illegal seeds can also be products which are not properly regulated and or distributed or sold in illegal way. So examples of illegal seeds which have stolen during the production and distribution process. Also seeds stolen from commercial trials, unknown seeds in counterfeit packaging, and also there are online seeds trading through unlicensed dealers. So other forms of illegal seeds are seeds that are sold as conventional seeds. Like, for example, in Philippines, I will discuss later that there are GM seeds which are sold as a conventional seeds. because they said that it's conventional, but they possess GM traits. So this is the case in Philippines. The fake GM seeds are sold in the market as conventional. You know, these are the F1 yellow corn hybrids stolen from seed production areas. There are also F1 yellow corn hybrid seeds bred and commercialized by local and unauthorized companies containing the BT or the insect resistant corn seeds and the hybrid or the herbicide herbicide tolerant seeds. So these illegal seeds do not come with, this is in the case in the Philippines where these illegal seeds do not come with a stewardship component. And this, for example, they don't have refuge seeds or they don't follow the insect resistance management scheme. And that is the regulation in the Philippines. So also the increased proliferations of these illegal seeds in the market put the biotech traits at risk by rapidly causing the technology fail, especially the Cryowen AB-based insect-resistant corn MON A10 and the BT11 of Syngenta. So these illegal seeds are being carried by various dealers and several distributors in more branding seed bags with more explicit GM claims and to the extent of bearing GM trademarks. So even if they are selling, they said that they are selling conventional, but still the bags has, for example, it states that it's herbicide tolerant. So it's really illegal because they don't follow the regulatory processes in the Philippines. So these are those genuine seeds that have been stolen from the production and distribution channels in Indonesia and India. And these seeds are illegally reproduced without the consent of the seed developer or owner, infringing upon intellectual property rights. This slide shows only the raid conducted by the police in Indonesia. And this is only the sample of the seized material. I think this is also in Indonesia. And in this slide, the other form of illegal seeds is the falsely labeled seeds or the unauthorized replicas of genuine seeds. They, you know, they said that it's their seeds, but it's only a replica of what our company is having. So that are falsely labeled and sold. They sold it as the same as the replica of other company members. So they are also using logos, misusing logos, and adding illegitimate trademarks to packaging. They're also making the seeds appear to be genuine, no? So this exploit and mislead the farmers, and these are sold at lower prices. So other form is the selling of seeds in the internet through different e-commerce platforms, like for example, Lazada, Shopee, and also Facebook. They are selling that illegal seeds in these online platforms. This is the example of online selling or selling on Facebook in India. So you can see it's almost the same as the genuine seeds, no? So basically, all parties throughout the seed value chain contribute to the production and dissemination of these fake seeds in some way. It includes agro input dealers, growers, producers, also dealers and brokers. We have also cooperatives, unions, grain traders, also politicians, and some unethical government recruits. So to fight the threat, our CropLife Asia teams are working continuously to counter these illegal seed practices. And with the increasing incidence of these illegal seeds throughout the region, CropLife Asia, through national and regional teams, have been developing a holistic advocacy response. So advocacy efforts include, strengthening the seed laws and the pertinent regulation, and also supporting the enforcement laws to combat these illegal seeds. We have also done information awareness through conventional and multimedia channels, and also training among farmers and consultation dialogues with the different stakeholders. We also conduct dialogues with these counterfeiters as well, and also with the government. No? So I think this is my last slide. Moving forward, just to provide you the checklist for avoiding illegal seeds. Only buy seeds from recognized and trustworthy dealer. When buying, you complete the document with product name and seed varieties, because sometimes you might have a complaint with the company, so you must have this one. So be wary of product with low prices with foreign labels, even if it's low, but it's not genuine. So don't buy those low price seeds, no? And packaging should be properly sealed with correct labeling. So please buy those with correct label. I think that's all. With that, thank you for your attention, and I'm happy to answer your questions. Thank you very much.
Any question?
Yes, thank you very much. Yes, I have a question, because you are talking about illegal seeds, but at the beginning of plant-based rights in Vietnam, the Vietnamese office complained about the fact that the seed companies never ask for plant breeders' rights. So my question, are you sure that the seed companies in all these countries are using protection and are asking intellectual property rights or brand and protection of the packaging and so on?
So much. Again.
You said it's illegal seed because you know it's illegal seed.
Yeah.
But I have also another example. You know, the Syngenta in China protested about some illegal seeds, but at the end of the day, they didn't ask for protection. They didn't ask for breeders' rights. So my question is, and a lot of vegetable companies, they didn't use for years plant variety protection. So even when it exists in the country. So my question is, are you sure that all the companies are asking intellectual property rights in these countries?
Can I request the company to answer the question? Because it's for the industry.
No, our survey of APSA says that the vegetable seed companies are very few coming forward for the PVP registration. I don't know, maybe because of the fast turnover of the products or cost or other things. So it's a very, very low turnover of the rights for the vegetable varieties. So because of that, maybe there is a reason that the counterfeit seed or the illegal seed is coming, because there is no protection.
Thank you. Let me cite the example in the Philippines. For like, in our company, East West said we really make it a policy before we release any variety commercially. We have to have PVP. So it's a that's the standard policy. So we don't release any variety without PVP certificate to guard against that. But also in the Philippines, maybe I could share, our seed law does not mention anything about illegal seed practices. They only talk about unlawful seed lot, but it's not defined. So we are revising the seed law, and we are proposing, a definition of illegal seed practices and stiffer penalties.
And that seed law includes all the issues that we have on illegal seeds.
Any other question? Thank you, Dr. Talima. So now we are moving to another topic, patent and PVP protection strategies for CRISPR. This presentation is online by Fabrice. He is a patent attorney and head of patent group, principal of Rouse and Company International, Thailand, and is also our member. We have now two alternatives. One, if he's available, because he has a case in there. So he's not available. So we are going to present his video on this topic. Yeah, please go ahead.
Hi, it's a great honor and privilege to be part of the Asian Seed Congress. Regrettably, I'm not able to join physically. Therefore, I prepared this presentation, and hopefully it will capture the essence of the today's topic, which is patent and plant variety protection strategy for CRISPR. As most of you may know, of course, various crop genomes, including rice, tomato, have been subject to genome editing using CRISPR techniques. In a very interesting quantitative review, over 100 genetically edited applications for agriculture were considered. And these findings highlight the huge diversity in a range of CRISPR applications, ranging from agronomic value, but also food and feed quality, biotic stress, ornamental, industrial, and so on. For many years, IP attorneys have considered CRISPR from only one dimension, which is basically intellectual property, looking at the possibility of protecting CRISPR through patent protection, but also plant variety protection. So let me give you a brief introduction to each of those two protections. Well, patent protection basically has exemptions. So in other words, they are field or subject matter that are not patentable, and higher life forms such as plants are not considered to be patent eligible subject matter. So a plant or plant variety itself cannot be patented. However, for plant varieties produced by new breeding techniques, which include, for instance, CRISPR, it may still be possible to indirectly obtain patent protection for the genetically edited plant. For example, the process or method by which the genetically edited plant is produced may be patent eligible. In addition, if the genetically edited plant carries a novel structure or sequence, the cell line that contains that sequence may also be patent eligible. Plant variety protection is, of course, different from patent protection. It must meet the following requirements. It must be new, it must be distinct. In other words, the variety must be measurably different from all other known varieties. It must be also uniform. The variety must be sufficiently consistent in its relevant characteristics and stable. The variety must remain true to its description of a successive generation. So if we consider basically those elements and look at the comparison between patent and plant variety protection, we can see they are clearly not overlap at all, but very much distinct type of protection. They may conflict eventually. So patents, we protect the process and also the end product, the gene, the trait. Plant variety protection, we cover only the variety, which is, different from microorganism or process we have referred under patent protection. And plant variety protection has specific exemptions referring to breeder rights and also privileges referring to farmers. Both patent and plant variety protection are eventually subject to invalidation, and that's a common technique during patent or plant variety protection litigation cases where if we represent the so-called infringer, we will try eventually to invalidate the protection. What is very important here that you may obtain a plant variety protection and be confident you can exploit it. However, a patent may be granted on some elements that are part of the plant variety protection, and eventually a plant variety owner may infringe an existing patent. So that's something which is not always well understood by plant variety owners, and therefore the interference, the interaction between those two types of protection is very fundamental to appreciate prior to launch any particular product on the market. Now, there is clearly a new paradigm and what I call the 3 dimensions. So we know that gene-edited CRISPR technology has been used in particular to address climate change, and it has been the subject of a lot of legislation and discussion on biosafety. So why are we looking at the 3 dimension? Well, for a simple reason that as far as patent is concerned and plant variety protection, we have said earlier that there is sort of understanding that in order to get a patent, a plant variety, somehow the plant, the crops must be distinguishable from naturally occurring mutation. Because if it's not distinguishable from naturally occurring mutation, you may not be able to get a patent at all, simply because you can't patent natural resources. But when it comes to biosafety regulation, it's very interesting to observe that there is now a very strong position taken by most countries in the world that CRISPR or gene-edited products or crops are very much considered as not distinguishable from naturally occurring mutation, and therefore are not subject to the legislation on gene or modified organism or GMO. And that's basically a first conflict between IP protection, which basically believe it is distinguishable from naturally occurring mutation, and biosafety regulations saying that CRISPR or gene-edited crops are not different from naturally occurring mutation. And then from a climate change perspective, we have seen a growing number of researchers saying that, well, CRISPR, because it's so much similar to naturally occurring mutation, could be considered as a nature-based solution to climate change rather than human-based solution to climate change. So let's look at it in more detail. So the first dimension is whether CRISPR is a nature-based or human-based solution to climate change. In other words, there is no human intervention or there is a human intervention. Therefore, it won't be considered as nature-based. Well, I won't go into the full description here, but this is analysis I've made looking at the different doctrine and authors considering whether CRISPR technology is the same as natural solution to climate change or not. And you can see there is no real consensus. Some believe that this is the same as nature-based. Some on the opposite, consider that they are key elements that really differentiate. And the author look at it from 2 perspectives: the process which is used, so the CRISPR process, the technology, and also the end products. once the technology has been implemented, is the final product the same or not, as if the solution would have been implemented naturally? And again, there is no consensus. And further study have been carried by researchers, and very interesting to observe that a couple of researchers, including Kistra, have finally reached the conclusion that CRISPR is what they call a bio-inspired solution. So in other words, a nature-based solution in their view. Therefore, it is not distinguishable from naturally occurring mutation. Again, this is something fundamental because, as I mentioned earlier, patent law and plant variety protection do take the view, in order to provide some protection, that the end product must be different from naturally occurring. Otherwise, it won't be patentable. So the second dimension is whether CRISPR is distinguishable from naturally occurring mutation from biosafety regulation. And again, the biosafety tests, you may know, have been implemented for many years now. It started through preliminary work done by national experts at the OECD, but is now basically implemented in many countries, and they look at not only the process used, but also the final product. So this is a map. In green color, you have all countries so far implementing the legislation according to which CRISPR is not subject to genetically modified organism legislation, is basically exempted from those requirements. And the reason why they're exempted from those requirements is because they believe this is a technology which is almost the same as naturally occurring mutations. Now, Europe is in red color, but there is definitely now an ongoing discussion to revise the rules on GMOs, to loosen some restriction for plants resulting from CRISPR. So eventually, Europe will turn into green color. So that is very interesting. Now, we have situations where, from purely biosafety consideration, CRISPR is considered as not distinguishable from naturally occurring mutation. And further analysis I've made, which is a bit technical, sorry to enter into the scientific aspect, but it's mostly the SDN1 within the CRISPR mutation that is really much seen as almost the same as naturally occurring mutation. SDN2 and SDN3 are, because of some level of human intervention and eventually foreign DNA, SDN3 considered as very much different from naturally occurring mutation. I think that's an important aspect to highlight. So what is the consequence of this conflicting outcome between the IP protection, the biosafety, and the climate change? Well, it's quite simple to understand. An interpretation according to which CRISPR is undistinguishable from naturally occurring mutations will lead to conclude that the CRISPR does not possess the markedly different characteristic from its naturally occurring counterpart, and may not be patentable, and may also compromise its protections as a plant variety because the lack of stability and novelty requirements. So long story short, yes, currently CRISPR is protectable under patent and plant variety protection, as I mentioned in the beginning of my presentation. However, if we look at the biosafety regulation, which clearly consider that CRISPR is not distinguishable from naturally occurring mutation, if we look at climate change solutions, which identify CRISPR as a nature-based solution, there is a very high risk that in the future, the patentability of CRISPR may be very much challenged because third parties will argue that this is basically patenting naturally occurring mutations. Likewise, plant variety protection may be at risk because of the stability and novelty requirement, which may not be fulfilled. Thank you very much. I hope I've been able to explain in simple terms a rather complex subject matter. Thank you.
Yeah. So, since he was offline, so we have No questions? Or somebody would like to ask question and somebody would like to answer? Yes, please.
Thank you. It's a comment rather than a question. You'll have noticed that New Zealand on that map was in red along with EU. New Zealand, of course, still has GM is illegal. CRISPR is receiving attention led by the Royal Society of New Zealand, and the Chief Scientific Officer for the Prime Minister have called for a discussion on CRISPR technologies in New Zealand. The incoming government has promised to initiate those discussions. So many of us are hoping that at least CRISPR technologies will be allowed to be used in New Zealand in the very near future. Thank you.
So you are discussing on the line of EU or the country which have already accepted certain guidelines for
along
CRISPR regulation?
the countries, well, it's a discussion to be had, but the thinking is along similar to the countries already accepted. Yeah.
Okay. Any other comment? So, okay,
maybe I have a question. For now, what is the situation in New Zealand? Do you accept patent on traits? And how you deal between the patent on traits and the plant variety protection of VUPOV on the variety which includes the patented traits?
Patents, yes, you can protect traits under the 2013 law. It is possible. You cannot patent varieties, but you can patent traits. As far as PVP goes, there's no specific restriction to protecting genetically modified organisms. The challenge would be in how you grow them and if they're allowed in the country at all. But in principle, you can protect GMO varieties. So there's nothing specific to prevent it, but there's other law and other practicalities that do.
Can you also protect native traits? Native traits. In
what sense do you mean for what native?
Already they are existing, but you discovered them. They already exist in some or the other form in the species.
Well, we have many protected varieties that originated as natural mutations. Of course, apples are important here, and there are a number of apple varieties that are protected that are mutations.
Natural mutation.
Yes, and they can be uniform and they can be stable. So that's something which I think is already occurring.
Okay.
And there must be thousands of protected natural mutations.
Any other? So thank you very much. We move further now. Now we have another presentation, a dark horse emerging on the CRISPR patent horizon and beyond, by Dr. Yuri Kim. She is Executive Vice President, General Counsel, Toolgen Incorporation.
Hi, good afternoon. So next. Okay. Okay, hi, Toolgen is a small Korean bio company, which is founded by Dr. Jin Kim. a renowned scientist in the gene editing community. So today, let me start with the famous Nobel Prize. These two star scientists published a science paper in 2012, which demystified how CRISPR-Cas9 bacterial immune system is working in vitro. So after 8 years since the paper publication and after the confirmation of the CRISPR-Cas9 system is working as a gene editing tool in eukaryotes, finally the Nobel Prize came in. It got me thinking that if the CRISPR system turned out to be not working in human cells, still would have they received the Nobel Prize. And on the other hand, some of you may be hearing intense legal battles in the US on the CRISPR-Cas9 patents. And some of you may be wondering why. I mean, don't the Nobel Prize winners take it all? But no, the winners doesn't take it all here. There are many other participants in CRISPR-Cas9 patent race. So among them, one of them, the Broad Institute, managed to secure a patent on CRISPR-Cas9 through a fast-track examination earlier than the Nobel Prize group, aka CBC. So this might have left the CBC group quite upset. In fact, they urged the US Patent Office to initiate an interference against Broad. What's interference? Interference is a special patent examination process when the multiple several parties are vying for the same patent on the same invention. So now we are faced with an intriguing question. When several parties are vying for a patent on the same invention, who comes out on top? And we have two solutions here. First to file and first to invent. I mean, now every country on the globe adopts the first to file system, which means we don't care who comes up with the invention first. Just raise your hand first, then you will get the patent. It's easy and most convenient for the government. But under the first to invent system, the one who invented the invention first will get the patent. Sounds fair and just, right? But it's rather difficult to figure out who is the first. So accordingly, the patent law became much more complicated. But up until 10 years ago, US is the only country which had maintained the first to invent system. So under the first to invent system, even though B filed earlier than A, which means B raised her hand first, but still B cannot get the patent. The A will get the patent because A invented first. So because the CRISPR inventions, they all made before the US switched come into under the umbrella of the first to file system, which means the US CRISPR inventions, the US patents shall be given to the first inventor under the first to invent rule. So parties are fighting for patent through interference, which is a legacy of the first to invent system of the US, and in which who is the first will be figured out. So ever wonder who is in the race for the patent of the Cas9 technology? So you've probably heard a lot about these two US big giants in the media. But here's the scoop. Turgen is in the mix too. So Turgen, CVC, and the Broad, they're fighting for the patent in the US under the first to invent rule. But look at the slide, you will notice the two double-headed arrows between CVC and Broad, which means they have gone head-to-head twice in this fight. So in the first match, CVC came up with CRISPR-Cas9 system-only invention. And on the other hand, the Broad with the CRISPR-Cas9 use in eukaryotes. So the US Patent Office concluded that they are different. They're separate inventions. So there's no situation in which who is the first should be figured out. So each party should take its own share and leave. That's the US Patent Office conclusion. And then CVC didn't agree and appealed. But this is the US Federal Court decision, which sided with the US Patent Office finding. Let me read some of an excerpt of the decision. When a colleague contacted Dr. Dodina to inform her of Broad's success, he stated, "I hope you are sitting down. CRISPR is turning out to be absolutely spectacular in George Church's hand." So the US Patent Office and the High Court, they concluded that applying this CRISPR Cas9 prokaryotic system into eukaryotes is unpredictable. It's not obvious. It has an inventive step. So it's different. So, sorry. So the CVC's goal, obviously, they didn't achieve their goal to take the Broad patents, right? But apparently, the CVC did not give up. within less than 1 year from the defeat, this time, I mean, they launched a second round, this time with the same, invention, CRISPR-Cas9 used in eukaryotes. But again, last year, right, the US Patent Office decided that Broad won, which means Broad is earlier than CVC for CRISPR-Cas9 in eukaryotes invention. And apparently, CVC didn't agree and appealed. So let's take a look at the real, situation, including other parties. See, Tulgen is earlier in filing its patent about CRISPR-Cas9 use in eukaryotes than the two juniors, Broad and CVC. And there are two provisional applications filed by CVC before Tulgen, but the US Patent Office didn't acknowledge these two because neither of the two contains experimental data demonstrating the CRISPR-Cas9 working in eukaryotes. So Tulgen is the earliest filer in the world with the application containing real working example. I mean, experiment data in human cells. So Tulgen, the senior party. So Tulgen's interferences against Broad and CVC took off in December 2020. And after more than 2 years of intense legal battles, the USPTO declared Tulgen the winner, upholding its position, I mean, Tulgen's senior party position. During the 2 years period of fighting, Broad and CVC, they bent over backwards to challenge Tulgen's senior party position, but failed. And what are the benefits of being the senior? I mean, among other things, junior party has to take the first shot. I mean, they have to submit their arguments and evidence without a clue about what the senior party is packing. It's like shooting into the air, hoping to hit the target, but not knowing where it is. By contrast, Tulgen can submit its story and evidence after receiving and reviewing junior parties' arguments and evidence. That this is a huge advantage in the legal battle. And according to statistics, the senior parties, they have a winning rate of about 75%. It's natural, right? The sooner an invention occurs, the sooner the patent filing follows. This logic is one of the driving forces behind the US switch to the first to file system. So how to win the battle? I mean, you win if you can prove either you created your invention. I mean, you made a working example of your invention earlier, or even if you made your, I mean, you conceived your invention later. I'm sorry. if you conceived your invention earlier, and work hard until your successful implementation, then you can win in this fight. So let me underscore just one point here to my dear scientists. The conception is not mere imagination. Conception is a definite and permanent idea of a complete and operative working invention. So picturing a flying car doesn't qualify me as an inventor in this legal fight. So in the second round, CBC and Broad, they submitted tons of evidence like lab notes, emails, and gel images, things like that. And the US Patent Office weighing all the evidence and arguments from both parties, they raised Broad's hands. So I would like you to get the hang of the process. This is one piece of evidence submitted by the CBC as a conception evidence. This is Dr. Inek's notebook. It's all in the public domain. So this is another piece of evidence submitted by the CBC. You know, it's Dr. Rabel's experiment and report. So let's briefly examine the timelines of the current ongoing interferences. CBC and Broad on appeal, they had extended the document submission periods to the maximum, causing a total 10 months delay. So now we anticipate the decision would be handed down, by the first half of next year. So until then, the Tulgen's interference are on hold. So what if CBC fails to turn over the USPTO's decision on appeal? Then CBC will be removed from the stage and leaving Tulgen and Broad, they will be contending with each other. And I'd like to label Tulgen as dark horse. So if you come across somebody who claims to know whether this CRISPR-Cas9 patent go to CBC or Broad, don't believe him or her. Here's why. Because CBC and Broad, they already fought, right? They already submitted their stories and evidence. So they all in the public domain. By contrast, only Tulgen knows what Tulgen has, right? The only person who saw all the evidence and arguments from CBC and Broad and Tulgen as well is Tulgen, right? So having scrutinized their stories and their theories and evidence, I am confident that at the end of the day, Tulgen will emerge as the winner. So what if Tulgen wins? Tulgen will be officially acknowledged as the US patent holder on CRISPR-Cas9 use in eukaryotes. And all the companies using CRISPR-Cas9 in eukaryotes for the US market are required to get patent license from Tulgen. So, but because of the uncertainty, right? We don't know for sure, technically. So because of the uncertainty and because Tulgen wants the CRISPR-Cas9 technology to be widely used for the world, so we will be decent. So in addition to CRISPR-Cas9 foundational patent, I'd like to highlight one achievement of Tulgen to exemplify Tulgen's expertise in gene editing. I mean, Tulgen scientists are pioneers who published CRISPR-Cas9 RNP transfection into animal and plant first in the world. And Nature reported this achievement because it is a significant breakthrough at a time when DNA transfection was considered the only feasible option. And long time ago, before the paper's publications, of course, Tulgen filed an international patent application. So that's all I prepared. Please visit Tulgen's booth and find out the secrets. Thank you.
Thank you very much.
Mm-hmm.
And good luck to you to get the final verdict.
Thank you. Do you have any question?
Yeah, well, you see the complexity of the patents and the usage may be whether we are getting from A or B. I think we all are user here and we want very, very good clarity that how we get the freedom to operate and from whom we get the license. So any question?
Yeah, you should take advantage of the current situation, you know, because of the uncertainty. You guys, I mean, potential licensee have the bargaining power, right?
Oh, good.
Yeah, that's what I think, and it's true.
Any question? Looks like too heavy. So you have to a wonderful presentation and very good defense you have taken against the two contenders.
Thank you.
Yeah, now we will move to online presentation by Mark Cool. You know that the Corteva has the license from the both CVC and Broad. So, so you have to listen to them that they have the rights to give you the freedom to operate. So let's see a licensing opportunity on CRISPR for research and product development using CRISPR-Cas9. Who is online?
Arvind,
Yes.
and
yeah, Mark.
Arvind, can you hear me?
Yes, we can hear you.
You can see me. You can see my screen.
Yeah, we can see you and your screen both.
Fantastic. Well, then, coming in just to the finish line. Thank you, everyone, for coming. And I'll speak a little bit about the CRISPR-Cas9 license opportunities in the current environment, I might add, with Corteva and various partners we have. So just to start talking a little bit about how we as Corteva use gene editing and our philosophies around this. So first off, the company, which was, of course, formed from various heritage companies, Dow AgroScience, DuPont Pioneer, and Pioneer Hybrid, we were formed in 2019 with a very clear and distinct purpose, and that is to enrich the lives of those who produce and those who consume, ensuring progress for generations to come. When we talk about consumers, that is a little bit of a different focus than most field crop or ag companies have had in the past. So that requires a fresh look at innovation. So we must look at food sources, environmental stewardship, food waste, the whole food story. So these are a whole bunch of different considerations that as a breeder, we have to think about as we're developing products, not only specifically targeted for farmers, the producers, but also downstream into the value chain to consumers and to society. We use various technologies to offer such solutions, such as traditional breeding, such as crop protection, such as biotech, seed treatments, but also agronomic solutions and newer breeding technologies as they emerge. All of that together is a toolkit that we use to create solutions geared towards solving the problem that we're confronted with. Genome editing at Corteva has various aspects. We're working on similar agronomic traits as we're used to with conventional or biotech breeding, but disease resistance, farm productivity, but also enhanced oil, enhanced food, and some more consumer-oriented characteristics. We also, as Corteva, very strongly have a smallholder farmer focus where we try to find solutions which help farmers, smaller farmers specifically, and then we really are focused on broad industry enablement. I'll talk briefly about both those latter points here in a moment. We are well positioned to harness the variation that exists in nature, in agricultural crops, using gene editing, because we have access to CRISPR-Cas systems, which we'll talk about. We have a very, very large germplasm pool in the major row crops. We understand the use of genome editing methods. We have very deep understanding of the biologics, of these crops. We've been working with them for 100+ years, and we have a very robust engine on how to take a product concept from discovery to launch. So we're really looking at using gene editing as a vehicle by which we can develop multiple new product concepts to provide the solutions that the future world will need in terms of food security and sustainable ag production. But when we look at technology and look at innovation, what really enables that? So first of all, it's the technology itself. You know, can we do it? Do we have the science available to us to do what we are wanting to do? Then we look at the policy. Are we able to, through regulations and government legislation, are we able to develop such products and bring them to market? But the one thing that we in the past as an industry did not think enough about, that is public acceptance. So not the what part of breeding, but the why part of breeding. So we feel that it's very important for us to be able to explain in public dialogue why we're using certain technologies, what benefits and value they offer, and engage society at large in a discussion to be able to talk about the work that we so proudly do, which is breeding and developing new plants and new solutions. To do so requires us really to engage in a full range of stakeholders that are different than stakeholders in the past. We're not only talking to regulators and scientists and universities, other seed companies and farmers, but we're looking at wider society and what their needs are and how we can answer questions they have. And of course, society has questions about breeding because largely society does not really understand breeding. And we shouldn't denigrate that lack of information or desire for more information. We should actually embrace that and be willing to talk about what we do. but that does take a lot more effort than we are used to in the past. What Corteva has done is we have established, ever since we took our research and intellectual property position in gene editing, we've established what we call a open innovation concept. And what that is, and we have a website here, you can go to the website, openinnovation.corteva.com. And this is a website in which we do a number of things. One is we have an open request for people to help us with certain scientific questions we have. And in some cases, we actually offer funding for people if they're able to work with us to help solve some of these questions. We also are interested in receiving requests for licenses on this website so that we have a way to identify who in the world might be interested in such a license. So this website is really a platform that we use to talk about gene editing and the opportunities that this provides. So answering again to start with the question why. So why did we have this concept of open innovation, which largely means sharing ideas, technology, and even intellectual property with other parties. So sharing rather than protecting. We did this really for three main reasons. One is to help answer specific research questions. I mentioned that earlier. The other is generally to advance scientific knowledge. If all of us learn more about biology of plants and how plants interact with the environment, especially if the environment is changing, then all of us together will be able to identify solutions and grow and leapfrog on top of each other and make significant scientific advancement. And we feel there's huge potential for that. And then doing so in collaboration in research projects to us is a very important criteria and a reason for having this open innovation platform. All of this together helps innovation, helps value creation, helps identify how breeding and how food production, obviously in our minds, benefits society. And again, being able to prove that both in dialogue but also in action to us is very, very important. So exactly who are we targeting with this open innovation concept? Really, it's pretty much everyone involved in plant breeding. And I must say that the work we are doing with CRISPR-Cas9 and gene editing generally is very much focused on agricultural crops and making genetic improvements in those crops. So we're not looking at animals or humans or even microbes or any other organisms. We are very, very much focused on crop breeding as we traditionally define it. So we work with academics, we work for nonprofit organizations, we work with consumer-oriented companies, startups, innovation hubs, other partners, big companies, small companies, private, public, anyone who's interested in accessing our technology knowledge and the intellectual property that we have access to is someone that we're very interested to speak with. So here's an important slide, and this talks about the different types of licenses that we are able to offer, or actually that somebody is able to gain and if they so desire. So if somebody wants to work in CRISPR-Cas9 space, currently there are a number of patent holders. So people who have invented various steps in the technology. There's actually about 60 patents in this space, so quite a large number. Most of those by far are inventions done by and therefore patented by universities, public institutions. MIT, New York University, University of Tokyo, Harvard, UCB, Vilnius University. Many of these public universities were early on involved in inventions in the CRISPR-Cas9 space. It is possible for somebody who wants to obtain a license in CRISPR-Cas9 to understand who holds the patent for the technology that they're wanting to use and access, and go to that party, go to that university, and obtain a license. Now, likely they will need multiple licenses because it's each license and each patent is quite narrow, and you need a number of patents to do any kind of serious research. But understanding what that is and knowing who holds that patent would be a way for anybody to access intellectual property, freedom to operate, and be able to do breeding work. That's a lot of work because there are a lot of universities, a lot of patents out there. So instead of going independently to each individual patent holder, it also is possible to go, so on the left-hand side, I'll start, to go to someone like Corteva Agriscience. We have a small number of patents on some of the enabling technologies for the Cas9 system through Pioneer and now through Corteva. And in cooperation with Vilnius and UC Berkeley, we have established a patent pool that we welcome people to come in, which has a certain defined amount of patents available to it. We encourage people to come in and obtain a license from us. That is, however, a license on that specific area. If there's a desire to access patents in a wider space in the Cas9 space, then it's possible to include the patents currently held by the Broad Institute in that discussion. So the way to do this is Corteva and the Broad together have signed an agreement in which we are willing to combine the patent pool that we have access to both individually, combine those together, and have opportunity for three-way license discussions with interested parties. So that would be a license between the Broad Institute, Corteva, and then this third-party licensee. So that is a patent access system that allows a very, very broad range of access to intellectual property and experience in using the technology, which would behoove a lot of plant breeders based on their needs. There are two ways to really access that three-way license between the Broad and Corteva. Quite simply, one would be to call the Broad, go to the Broad and ask them for a license. Or come to Corteva and ask us also for a license, for this joint license. Both discussions will be the same because both would be based on a standard license agreement that the Broad and Corteva have developed, but there are two ways to enter into that license. So people can go to independent license holders or inventors or patent holders of each technology. They can come to Corteva, Berkeley, and Vilnius and access that subset of licenses or patents, or they can come to the Broad and Corteva together to be able to access a very wide range of patents as considered necessary. I very much encourage anyone who has an interest in this to contact me, and I will show my email address at the end of this presentation. So the license terms that we have are quite straightforward. As I mentioned, the IP coverage in the beginning. These are non-exclusive licenses, so everyone has the ability of doing any other licenses they want. And then there, of course, would be a royalty fee because there is eventually commercial value in such licenses in using the technology in accessing the patents. There are two types of royalty agreements. One would be for pure research-only purposes for academics, and that does not carry a license fee. So that is for free. We do like to have research agreements with parties who are doing research only, and if those parties eventually think they will commercialize or sell a product, it would be smart in advance for them to have some insight into what the commercial criteria could be. And then there's the ability of doing a commercial license. When you develop something that has value and sell it, then a royalty would be due back to the Broad and Corteva together. These are independent licenses, so everyone can do any other kind of license they want. And then we have some rather strict stewardship requirements. I won't go too much into depth here, but it's very important for us that certain things are not done with his technology in plants, and also that the technology itself is stewarded within people's breeding programs very well, so that they know exactly how they're using the technology. They have the right permits if necessary for any trials, any field trials. They also have the appropriate regulatory approvals as needed prior to commercialization, and that they track the use of the material through the breeding, production, and commercial program. But we don't allow work on gene drives. We don't allow work in terminator technology. We prefer not having work in herbicide tolerance, but that isn't a black and white situation. We can have discussions about that for obvious societal reasons. But these are some of the very strong stewardship requirements that we have. So I mentioned our philanthropic pillar. So we do have a number of non-monetary license agreements around the world, heavily focused on smallholder farmers. We're working, for instance, with MLN in Africa, maize lethal necrosis, working on sorghum that is resistant to striga, which is a devastating disease, working on improved pearl millet, which reduces rancidity in pearl millet, which allows for longer storage and creating a better food product. So a couple of quick comments about policy. So the general definition that most policymakers use is that gene editing, as opposed to biotech or GMOs, there's really two triggers. One is there's no foreign DNA in the species, so no DNA from a sexually non-compatible plant, a different species that is in the plant that we're targeting. And number two is that the changes could occur in nature or could happen through conventional breeding. But the trick here, which is the differentiation between, in many cases, patentability and non-patentability for such a naturally occurring system, is that the outcome is something that hasn't happened, likely wouldn't happen, and is the result of a human intervention, what we call a repeatable technical step. So that is the defining factor there. The rate of the technology adoption really is going to be dependent upon the regulatory framework. If a country has a very, very strict regulatory framework, that will naturally keep people away from using gene editing, and that will reduce the potential benefits and value to farmers and society that technology would have. And this is such as in biotech. Often the critique on biotech is that only a very small number of companies in very large crops on a global basis with a very limited number of traits are able to use the technology. The reason is because of the regulatory burden. So the regulatory burden needs to be appropriate, but it can't be such that it prohibits companies or disincentivizes companies from using the technology. As an example, in Argentina, which in 2015, as the first country in the world who established a process by which plants could be validated if they fell under the GMO framework or not, so if they were conventional or GMO. In Argentina, prior to that, prior to 2015, you can see on the left diagram that 90% or almost all of the applications for regulatory approvals were by multinationals. In 2015, Argentina established its gene editing policies, and on the right-hand side, you can see that already in 2020, that shifted dramatically. 60% of the applications now for deregulation in Argentina come from local companies. A lot of foreign small and medium enterprises are accessing the Argentine market, and the market share or the share of applications, I must say, for gene-edited products is much less than it was for GMOs. So there's a dramatic shift and the enabling capacity of the technology for smaller companies. Likewise, you can see on the left that prior to 2015, most of the deregulatory applications were based on plants, and they were based on two traits: herbicide tolerance and insect resistance, which is biotech, which we all well know. On the right, you can see that after 2020, the applications, number one, increased dramatically for animal and microorganisms already within 5 years, and that the applications were also over a much larger set of characteristics. So that shows how the technology can be used and is used by many smaller companies for many other purposes. So just a comment about regulatory frameworks. So the important thing in each country in the world is each country has different laws, and they have to use their laws to come to the same policy point. But the commonality between the path that each country could follow is that they can establish agreements between countries on what the criteria are to determine the appropriate scope of regulatory oversight, conventional versus GMO or something in the middle. And then there can be a agreement on the kind of information that is needed to be presented in order to be validated against that in that sense. One last comment I will make is that when a product is developed using modern technology and is regulated or deregulated or verified as being non-GM or whatever the terminology is that you use, there still are a large number of other regulations that apply to that product. There's plant variety registration systems, there's seed laws, there's phytosanitary regulations, there's safety laws, there's food feed laws. There already are a number of other laws and regulations that apply. That does not change with the advent of new technology and with the fact that a product is regulated as a GMO or not regulated as a GMO, it still is regulated under the seed laws of the country. And with that, I wanted to end and thank you very much.
Thank you, Mark. Thanks a lot. Any question to Mark? Well understood, I think. Mark, I have one question.
Please.
One question.
Oh, there. Okay. There's one question, another question.
Hi, Mark. This is Kaula from ISF. Just we had the previous speakers talking about toolgen. So where is when you presented that slide about the different patent and so on, where is toolgen in that whole landscape?
Yeah, Khulud, thank you. It's a good question. So this describes the current patent landscape. We're well aware, of course, of the discussion with toolgen, and we take no stake in any of that discussion between these three parties. We are very willing to work with any of those parties. For us, the important thing is being able to access and use the technology as a package for breeders. And if that comes from one or the other party, it really doesn't matter to us. Currently, the UC Berkeley and Broad patents describe the patent landscape well. If that changes in the future, then our approach would change as well. So we support anyone in the discussions they're having. Arvind, please.
Mark, we are using three in gene editing: SDN1, SDN2, and SDN3. What is the advantage of using SDN1 and SDN2, the non-homologous and homologous joints?
First of all, those are really becoming quite outdated terms, but it's an easy term for a regulator to understand. If you talk about a delete, an edit, or a insertion, then that becomes something maybe philosophically easier to understand. But the first, so SDN1, which is a simple deletion, is something that was initially done in plant breeding. We actually have a product, a waxy corn, in which we used CRISPR-Cas9 gene editing as a way to mimic a naturally occurring deletion of a waxy gene in corn. By the way, because it was mimicking a native gene, it's not patentable, but we did use technology to create that. but that was an early product concept, and we in our breeding work have moved on actually well past SDN2 and even SDN3. So I would say there's no advantage or disadvantage of either. There are different concepts, but actually the borders between them have become more blurred, and the technology has even moved on further than that, where we're able to use gene editing as a way to identify, understand, and use the existing variability in the current crop species to a much greater extent than we have up till now. So that is the real promise and excitement of gene editing.
Okay. Any other question? If not, thank you very much, Mark, and enjoy yourself now, and we will wind up.
Thank you.
Thank you.
Have a great day. Bye-bye.
So now we have the, I think we are overshooting time, and now we have the final short summary by Francois.
Thank you, Mr. Chair. First of all, I would like to remind some consensus we have. The first one is the fact that without any doubt, we need to accelerate the genetic progress. The second, we talk about during our workshop on EDV is the fact that genetic progress is incremental. The third one is the fact that breeding is mainly a work of poor people, poor companies. And the margin on self-pollinated crops in Europe is less than 5%. And we have never to forget that. Fourth, we need to have access to new biotech. There is no doubt about that. And my second remark is we saw this afternoon that we have a lot of new debates on the table. And we have to remember and to remind to everybody that there is a specificity of food and agriculture. And here is the link with the international treaty. You know, when we had the CBD, he said, yes, but we can't work with food in agriculture as we work in the other industries. And maybe we need to imagine again something. You know, before UPOV, we try a lot of intellectual property rights. We tried patents. And at the end of the day, we said, no, we need our system. Maybe we need to imagine a new system which will answer to all these technologies. And to conclude, I just want to insist about the fact that it's the role of a standing committee of APSA on IPR to create this debate, to create these exchanges, and maybe to allow APSA members to imagine how to answer to all these questions. And just one word before to leave you in the hand of Arvin. We, at the last standing committee meeting, we think to work on a new position paper. You know, APSA had a position paper on intellectual property rights for a long time before all these new tools and new debates. And we thought it's very important for APSA to work on a new position paper to answer these questions. And it will be the work of the next year. It was agreed by the executive committee. And so you will have a lot of work in the next months and years. Thank you very much.
Thank you. Thank you all for very patient listening. And now we finish our meeting.
A good photo with all the people online.
So may we invite the chair and co-chair and all the resource person and Dr. Shivendra Bajaj to take a group photo with the IPR and Biodiversity Committee. Thank you.